But may I praying was the order passed. 16 June. Stamp folio already deposited, but not certified copy not ready.
My lord, I seek to file an
আমাদের তো রেকর্ডিং চললো, তো এখানে চললো কেন হঠাৎ?
if I may. My lord, I seek to file an appeal, but I seek leave to file it without the certified.
When was the order passed?
11th of June. I'm within the period of limitation.
What period of limitation? When did you apply for certified copy?
My lord, 23rd June.
Yes, granted.
Thank you. But
may I permit to mention, your lordship, this is an contempt application.
Original side?
No, my lord. Yes, my lord, it's the original side, but my lord, bench is my lord Justice Banerjee, my lord Justice Supratim Bhattacharya. My lord, today's new application, item number. Appellate side today's list, my lord. There is a matter listed in as item number 5. That matter also before the bench of my lord Justice Banerjee and my lord Justice Supratim Bhattacharya. That has been listed, my lord, today as item number 5.
Commercial or non-commercial?
Non-commercial, my lord. Non-commercial appellate side.
Why do you say, is it parted before that bench?
No, my lord. That will be appeared for the
But a
for first
contempt.
time. Contempt, my lord. Contempt.
শোনো, বুঝতে পারছো কি বলছেন? 5 নম্বর আইটেমটা ইজ এ কন্টেম্পট অ্যাপ্লিকেশন। Bhattacharya and me, whose order is
My lord.
whose order has been violated?
My lord Justice Banerjee and my lord Justice Supratim Bhattacharya's division bench.
No, my court officer says no, you're not right.
I have the contempt
দাও তো আমাকে
application
দেখো।
with me, my lord.
সি প্যানটা দাও না আমাকে।
That was assigned, my lord. That matters were assigned to that bench.
Justice Muralidharan and me.
And that matter has been assigned. Thereafter, that matter was assigned to that bench, my lord. That my lord Justice Banerjee and my lord Supratim Bhattacharya.
There is no such assignment. Anyway, we are wasting time.
May I have your lordship's leave to? My lord, I am appearing virtually, my lord. May I have your lordship's leaves to address my lord Justice Chattopadhyay regarding a contempt application, my lord?
Yes.
Yes. Yes, please.
My lord was pleased to pass an order regarding a writ petition, my lord, where petitioner is a
What do you want?
live convict.
What do you want, sir? Inclusion?
Inclusion, only inclusion, my lord.
Apply the number, it will be included.
Deeply, man. Deeply obliged, my lord. Deeply obliged. Beg you kindly, my lord.
তুমি বলবে বাবু। রেখে দিয়ে sciatica drops.
Yes, Mr. Bhattacharya.
Yes. But Mr. Bachawat
is in serious need of this medicine right now, which is being manufactured by my learned friends' clients, sciatica drops. But this is a suit for infringement and passing off.
Your application has not been allowed.
My lord, initially I was granted an interim order. The interim order continued for about almost a year, and after that it was vacated on the ground that one of the family members gave an affidavit after filing of the suit saying that this is a family mark. My lord, will kindly see the cause title. Both are companies. The promoter directors of the defendant company were my directors, shareholders. They have received money for transferring their shares. Their personal guarantees have been released. After the order has been vacated, my lord, they have again come back to their old game. My lord, these are the actor. For sciatica, Mr. Bachawat has been suffering from this for a while.
Bachawat has come to court.
He's on his way.
Well, may I? The order is completely unreasoned. If your lordship kindly takes the order, my lord, which starts at of the state petition, volume 4, page 602. My lord, kindly comes to
Internal page.
paragraph 41 of this order. My lord, there is no reasoning. Till paragraph 40, the judgment records the submissions of the parties. Lordship can also consider paragraph 40, my lord. No reasons whatsoever. The mark is registered in my name, and it was registered when the promoters of the respondents were directors and shareholders of my company. They're all related. They're brothers and all. And the name of the company has been changed. It is now Aprive. But your lordship, I have just handed over the pictures. Your lordship will kindly consider.
Did you file any suit before the Delhi High Court?
Yes, ma'am. Yes. We had withdrawn it.
Claiming the same relief.
My lord, I'll tell your lordship, the Delhi High Court, before passing the interlocutory order, said that we need to go into the question whether we have territorial jurisdiction or not. I'll show those orders. Delhi High Court then came to a finding that it does not have a territorial jurisdiction.
Mr. Bhattacharya, we don't have time for multiple hearings. File in, if you have annexed all papers.
Every documents annexed.
The state petition.
Till that time, my lord, I've just handed over.
29th April was the order. You filed this appeal on 10th of June. So if you could wait for that period, you can wait for a week. Come back next week, we'll hear out the appeal.
But in the meantime, my lord, what has happened? I have handed over this picture. Very recently, last week, my lord, will kindly see that picture.
Mr. Bhattacharya, without applying our mind fully.
30 seconds. My lord, kindly takes that picture. My lord, at the top left,
This is whose product?
Their product.
Their product.
Their product. My lord, they have changed the name of the company to Aprive. Now, this is a violation of the Drugs and Cosmetics Act. If your lordship sees the right-hand side, manufactured by Dr. Elias's New Life Homeo.
They're still selling it.
Which they had changed the name. This is a clear violation of the Drugs and Cosmetics Act.
They'll face the consequences.
Yes.
They'll face the consequences.
Let them not use this.
You complain, right? There must be a competent authority. Write to them.
Well, then, will it be a lordship's pleasure to fix a
Yes, a date, not a time. Tell us, both of you.
I am.
Only the question of limitation I had pointed out on the last date.
What limitation?
Because order passed on 29th April.
Yes.
Normally, the limitation would expire within the date of vacation, during the vacation. court reopened on the 9th of June, filed on the 10th of June. According to Section 4 of the Limitation Act, it should be
Well,
filed
Mr.
on the
Mr.
day of-
Kundu, Mr.
One
Kundu,
day
let us,
delay. Yes.
Mr.
There's
Kundu,
a 1 day delay, my lord. We had sought for leave to file it without the certified copy. My lord, the leave is there, my lord, behind the memorandum.
We'll condone the 1 day's delay, Mr. Raju. Ignore it.
pointed out.
he has earned his fee.
You have pointed it out.
That is it.
Now give us a date
But any.
within the period of limitation.
But all documents before the trial court are before your lordship.
The opposition of your opposition before the trial court has been.
Yes, it's all on record.
Why? This is not as easy as Mr. Bhattacharya points it out to be. My lord, there was
Mr. Roy Chaudhary, file an opposition before the next date. Your stand is already on record.
Yes, it's already on record.
Why
all
do you,
documents
why
before
do
the
you
trial
want to multiply affidavits? Don't multiply pleadings. Give us a date.
Monday or Friday.
Well, 22nd, Monday, 21st.
Mr. Tiwari is assisting you.
Huh?
Mr. Tiwari is assisting you.
I don't know how much he is assisting me.
July, yeah, meeting.
Monday.
Oh, no, not 21st July. 21st July is a dangerous date.
next week.
25th, হবে তো?
25th. 28th.
Then 25th.
No.
Right.
21st is a dangerous day. 21st, my lord, coming to court is a. তারপর আমি অন্য কোনো চেন্নাই আছে আমার।
হ্যাঁ, তার আগে করো।
তার আগে কবে হবে? 28 তারিখ হবে?
হ্যাঁ,
20
28th on Monday.
25th হবে না।
28th.
No, my lord, not 28, 28.
29th not a commercial day.
Oh, it's not a commercial.
ওই ফ্রাইডেটা করে দাও।
29th নেই, চেন্নাই।
তাহলে তারপরে মানডেটা করে দাও।
ওসমান।
হ্যাঁ? তো কি হয়েছে ওসমান?
দিল্লি।
তো আমি কি করি? তাহলে তারপরে রাখো। 9th every Monday and Friday is Mr. Bhattacharya.
Miscellaneous day, na?
Time fix for the.
My lord, 11th of August.
Yes, done. Issue. This appeal is directed against a judgment and order dated April 29, 2025, whereby the appellant's interlocutory application for injunction has been dismissed by a learned judge of this court. Paragraph, we need to hear out the appeal. Stop. Mr. Bhattacharya, learned senior counsel representing the appellant, tells us that all papers that were there before the learned single judge have been annexed to the stay petition. Stop. We shall treat the stay petition as an informal paper book. Stop. All formalities are dispensed with. Stop. Since the respondent / defendant is represented through learned counsel, notice of appeal is deemed to be waived. Paragraph. List the matter on August 11, 2025,
Would it be a lordship?
as agreed upon by and between learned counsel for the parties,
Would it be a lordship?
marked 3:30 p.m.
Great. My lord, only one prayer. I am praying that they should not. Your lordship rejects it, but let it. But only one prayer that recorded, my lord.
Paragraph. Mr. Bhattacharya says that after the order of the learned single judge was passed, the respondent defendant has changed its name to Apriway, 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 from Dr. Elias New Life Homeo and Dr. Elias New Life Homeo and Herbals Private Limited. Stop. This is a violation of the Drugs and Cosmetics Act 1940, violation of the provisions of the Drugs and Cosmetics Act 1940. Stop. He prays for an order of injunction restraining the respondent from manufacturing the concerned medicine under the name of Apriway.
No, the name Dr. Elias.
Under the name of Dr. Elias New Life Homeo and Herbals Private Limited, since the defendant has changed its name. Paragraph. Without fully applying our mind, we are not inclined to pass any order. Stop. However, it will be open to all concerned to draw any irregular or illegal act that the defendant may be committing in violation of any statutory provision to the relevant statutory competent authority.
May I point out one thing? This
Yes.
may be a bit misleading. The manufacturing date of this product is May 2023. Probably not the same product.
Cash memo to that.
Cash
No,
in
my lord,
that
very
instant
interesting thing.
We have not passed any order, Mr.
My lord, very interesting, very interesting thing.
We have recorded his submission, good, bad, indifferent, incorrect, whatever. We have not passed any order.
My lord,
Are you
open to them.
Are you
we will have the chance to
I'm
defend.
disputing this because this is my
Let it be
manufactured
disputed.
in May 2023.
learned aita kore dao, learned advocate for the respondent strongly disputes the submission,
But they're saying it now.
submission made on behalf of the appellant,
Manufactured.
as also
This is manufactured. That is
Cash memo, cash
misleading.
memo, cash memo.
the authenticity, as also the authenticity of the Xerox copy
Yes.
of the defendant's product that has been filed in court today. ওটা রেখে দাও।
Yes, my lord. This is very important because it's being
May I
handled over
may I tell your lordship a very interesting thing, because this entire dispute. So Dr. Ilyas was the father of the promoter of Mr. Rai Chaudhary's client, which is a company, Dr. Zaki. My client is Dr. Zakaria. The dispute is, according to him, this homeopathy business was started by Dr. Idris, who is the grandfather. So I had given this analogy to Justice Rao. Maybe your lordship is also not aware. P. Banerjee homeopathy, your lordship is aware of, and the name is registered. But does your lordship know who started this homeopathy business?
P. Banerjee's homeopathy business.
Does your lordship know who's the ancestor?
Dr.
And-
Adri,
And that's why he used to
Dr. this gentleman you are naming.
Ishwar Chandra Vidyasagar.
Yes, you're right.
At his late age, he started, and he was the nephew of Ishwar Chandra
I
Vidyasagar.
know Mr. Bhattacharya because Dr. Pradeep Banerjee, Dr. Prashant Banerjee's son, was very, very dear to me. We were very, very close friends. Pradeep died suddenly.
Yes.
during COVID.
Yes.
I was his patient.
No, I know that family very well. I've heard this.
Started by Ishwar Chandra Vidyasagar.
Mihijam in Mihijam.
Yes, my lord.
Yes, you're right.
Grateful. বসো চারটা শেষ হোক।
That also clarifies Ishwar Chandra Vidyasagar was a Bandopathyay.
Item number 2.
Your Lordship, I am appearing on behalf of the appellant. I am led by Mr. Gunjan Shah in this matter. I am praying for a very short passover, Your Lordship.
Passed over.
Well, I'm opposing this application,
Yes, my lord.
and the
I am for
appeal
the
on the ground that it is not maintainable.
My lord, I'll satisfy your lordship.
Execution of a purported
Let me
award.
move the appeal. Let me move the appeal, my lord. I'll satisfy your lordship on maintainability. But at the outset, my lord, we had indicated to your lordship, my lord, there was a settlement, my lord. There's a mediated settlement which takes the character of an award. Now, my lord, we had filed an application for execution of this award. The learned single judge was pleased to record that this is not enforceable as an award. From that order, we come up in appeal before your lordship. Now, what is transpiring, my lord, is that the award contains one provision, my lord, that there is an electricity substation.
No,
That's-
first, maintainability has to be addressed.
I will.
When it is
I am not
maintainability-
shying away from addressing your lordship on
First,
the
maintainability
maintainability,
has
but
to
on the
be
last occasion also, your lordship said, since your lordship is hearing the appeal, my lord, the status quo cannot be altered. So we have made an application.
He will go on enjoying electricity without paying.
Kindly allow me to
Document
finish, my lord.
9
Without
lakhs
interrupt-
is due.
And
When first deposit.
it is alleged in 2025 that the due is from 2018. On this purported basis, electricity is supposed to be disconnected to me now, while the appeal is being heard by your lordships. Kindly see the interim application that we have filed, my lord.
No, the electricity is not the subject matter of this
My lord,
appeal.
I am sure my learned senior friend will have his say, my lord. Kindly allow me to
I
move.
did not have a say when I had COVID.
My lord will kindly have the IA. IA number two. IA number 2, my lord. In order to possess. My lord, in the IA,
Some of the parties appear to be very familiar to me.
yes. Public order. My lord, 16 June, Lordship had been pleased to pass an order, my lord, that the appeal be heard out itself without the, my lord, dispensing with the stay application, because, my lord, undertaking by the party that they will not do anything
Correct,
to alter the
correct,
status
maybe,
quo.
but what I am on, Mr. Shah, some of the names appear familiar to me. I am very particular about these things.
My lord, I'm sure neither of us have
Even-
any difficulty, my
even
lord.
though
I
That's
definitely will.
very magnanimous of both of you, but that is not good enough for me.
I will not.
Allow me to.
My lord,
It's a
some
question of my conscience.
I appreciate, my lord, but some protection, if not granted, my lord, will make the appeal infructuous, my lord. If they alter the status quo today, there is already a.
No, but
But it will kindly
Let me satisfy, my lord, on the since
paragraph 101 of this
appellability is being challenged. Let me satisfy your lordship on that only so that limited protection I can ask for today, my lord.
no, if I grant you limited protection, then I might as well hear out the appeal.
My lord will appreciate, my lord. There's an undertaking on the basis of which lordship has disposed of the stay petition.
That undertaking is not with regard to enjoying electricity at my expense.
In 2025, on the basis of purported debit notes raised in 2018, they seek to disconnect electricity, my lord, while the matter is being heard. And undertaking has been given that they will not alter the status quo, on the basis whereof the stay petition has been disposed of.
We have said we will not transfer the shareholding and all. No undertaking given with regard to them enjoying electricity at my expense.
Undertaking is not recorded in the order.
No, my lord, undertaking not recorded in the order, but we were all before your lordship, my lord. We will not misrepresent what is transpired in court.
You can't expect us to remember, do you?
Certainly not, my lord.
Because
That is not the subject matter of appeal. But whether it is an
you-
award,
Mr. Shah, Mr. Senior Shah had said it's recorded in the YouTube.
Yes.
we have the YouTube video. We have the YouTube video. 16th of June. We have the
Yes.
with regard to shareholding and the land.
Third party rights.
Third party rights with regard to shareholding and land. They cannot enjoy electricity at my expense. It is only with regard
Mr.
to
Bhattacharya, I'm only asking, was there an assurance meted out by your client
yes, I will.
regarding
will be candid.
regarding electricity?
No.
Not specific to electricity, my lord, because this
I have the YouTube video. I can.
they said they will not take any precipitate action, my lord, to alter the status while the appeal is being heard. Not
Because
particular
that
to
day-
electricity.
I had COVID. I could not come.
Status of what?
My lord,
And land.
Is that mentioned specifically?
no, what,
That is the subject matter of that purported award.
my lord, I'll tell you all, this undertaking has to be contextualized in the
was given
with
by Mr.
regard to the
Banerjee.
prayers.
Let him address your lordship.
I'll clarify this, my lord. Learned senior Mr. Shah had addressed this court and had sought for a stay order. His words were status quo because the threat perception was that third party rights will be created. To
That's not correct, my lord.
to that I said, I give an undertaking, no such thing will be done.
With respect to shares and land. Because that is the subject matter of the purported award.
It was in 16 June. I have rechecked this.
Kindly-
I have rechecked the video.
If your lordship will care to see my IA, my lord, on the basis of debit notes in 2018, they're purporting to terminate
Mr.
the
Shah,
electricity connection
without
now in
wasting time,
2025.
we'll immediately get it typed, sign it, upload it, apply today, get an assignment, move it on Monday.
My lord,
It's going to be very difficult for me. I didn't notice the parties before. Some of them seem to be very familiar to me, Mr. Shah. Allow us to release this matter. We'll ensure that the release order is uploaded within the next 1 hour, so that you can apply for an assignment.
If today, my lord, this is how, my lord, parties can succeed in getting, my lord, matters released from the bench.
I have
Nobody has said anything.
Then,
Oh,
my lord,
nobody said
my lord,
anything.
there is,
Why-
there
why
is,
is Mr.
my lord,
Singh
then my lord, I don't see, my lord, any reason for which your lordships would otherwise want to release.
Some of the parties seem familiar to me.
Oh,
I never made any submission.
It's from us.
oh, I see.
Hey, Ishu. We are not inclined to take up this matter on the personal ground of one of us. Bracket আমার নাম দিয়ে দাও, paragraph. Let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction. এইটা এক্ষুনি টাইপ করে আমাদের দিয়ে এখানে সই করিয়ে নিয়ে আপলোড করে দাও।
I'm still willing. If your lordship kindly takes it up, I have no difficulty in that.
You may not have any difficulty. We have. I have. Mr. Bhattacharya, today you are appearing. Today Mr. Shah is appearing. Tomorrow somebody else may be appearing.
So Mr. Shah kind of made an imputation as if I have asked your
No, no,
lordship.
I'm sorry, my lord, I was not present, but that is the impression I got. I apologize to my lord.
He did not apologize. He is senior to me. I respect him a
No,
lot.
my lord, that is a misimpression wrong impression. But my lord,
You move it on Monday before the other bench. You get it assigned today.
ঠিক আছে, ছেড়ে দাও।
Item number 4. Now that I appear for the plaintiff respondent. And an
This is my-
application under Order 7, Rule 11 has been dismissed.
Lord, my appeal, my lord. Lord, I made an application, my lord, on the ground that part of cause of action for this suit had admittedly arose outside the territorial jurisdiction of this honorable court, but no leave under clause 12 was taken. And on this ground, my lord, an application was made for dismissal of the suit, my lord, rejection of the plaint. This has been rejected, my lord. The impugned order.
To be heard out. But your lordship kindly looks at the impugned order, well reasoned. Paragraph 1, paragraph 3, paragraph 6, and paragraph 10. 4 paragraphs your lordship looks at.
Of the impugned order.
Impugned order.
Lord, may I present my appeal, my lord?
Please,
Mr. Bhattacharya will have his say, my lord. My lord, the short point is, my lord, even the cause title, my lord, says, my lord, the defendant, number 1, my lord, had its registered office outside the jurisdiction of this honorable court. Well, it's a simple case of money lent and advanced. But the transactions, my lord, substantially was within the jurisdiction of this honorable court.
The defendants are all within jurisdiction.
No, my lord, kindly takes the cause title.
Takes paragraph 10 of the impugned order.
Kindly,
We are taking the cause title of the order,
Yes,
impugned order.
my lord, kindly take the plaint. My lord, kindly takes the plaint, my lord,
Have
at
to
page
be-
29.
Are you suggesting, Mr. Singh, that the cause title of the plaint is different from the cause title of the impugned order, which the impugned order
Cannot
is
be, my
carrying?
lord.
If that is so, take the impugned order, take the cause title.
Yes.
All the defendants are within
No, my lord,
jurisdiction.
my lord, the 236B AJC Bose Road is outside. My lord, my lord, kindly see, my lord, there are
Yes,
two offices.
and office at
And also,
Park.
now, my lord, the registered office is outside.
Hmm.
One of the offices is within.
Carrying on business.
Carrying on business also within,
Yes.
but the registered office outside. That's the short point, my lord.
Yes.
But now, demand notices were served outside,
Yes.
including inside, at both the addresses.
Cause of action, Mr. Singh, will only become relevant if the other clauses of clause 12 do not apply,
Yes.
which is carrying on business is one.
Yes, my lord.
It is enough to say that the defendant is carrying on business. The registered office may be in Timbuktu. Doesn't matter. So, clause 12 says so.
Yes, yes. I'll satisfy that, my lord. I was anticipating this, my lord.
Yes.
It's not only cause of action, my lord. It says, my lord, there was a demand raised outside, and because of failure to pay, there is a cause of action now. Now, my lord, this simple question that I pose, my lord, here, my lord, is whether in these pleadings, where this defendant plaintiff says that I raised demand at Alipur to one AGC Bose Road office, and there's a failure. On these pleading, whether the suit could have been filed before the Alipur court or not, my lord. If there was a cause of action, if the plaintiff could have instituted the suit on these pleading before the Alipur court, my lord, part of cause of action is outside and leave is mandatory, my lord. In my respectful submission, my lord. Well, kindly visualize from this angle, my lord.
No, no. What if two courts both have jurisdiction?
Part of cause of action is outside, my lord, if that is the case, because the cause of action has pleaded also says that the demand raised outside and there's a failure to pay, and therefore.
But if the plaintiff does not invoke the jurisdiction of this court on the basis of cause of action.
Yes.
Carrying on business is another ground which clause 12 mentions.
Yes.
This is not section 20, right? So that's enough. Carrying on business, full stop. Now, if you dispute that, that's a question of trial on evidence.
That's a question of trial, will it?
That's
different. Is not in dispute.
Then nothing.
But
at this stage, there's no question of rejecting, Mr. Singh. At this stage.
Will it kindly only
we will keep the point open, maybe? We'll keep the point open if you like.
We'll then kindly hear out the appeal because there is an order.
We are hearing out the appeal.
Order 12, Rule 6, and they know they have no defense to that.
No, we are disposing of the appeal. What remains?
Nothing will remain after this, but my lord kindly considers this, my lord. There are two parts of the cause of action as pleaded in the plaint. One, carrying on business.
Original side rules, but let us page.
If the defendants are carrying on business within, nothing more remains.
This is what I was telling, Mr.
That's the only. That's not the only case as would appear from the cause title itself, my lord. But I completely understand what's going through my lord's mind. My lord will also see the pleadings with regard to part of cause of action having arisen outside.
Maybe.
So my lord leave in that
not
event.
Necessary. Not necessary. Not necessary because of clause 12. Look at the language.
May I?
Very simple. Or if the defendant at the time of the commencement of the suit shall dwell or carry on business or personally work for gain within such limits.
So, my interpretation, as it appears from the plaint, that if it is the case that the defendant carries on outside as well,
yes,
as well as within,
yes,
plus the fact that part of cause of action admittedly arose outside, leave perhaps would be required. If my lord is not with me, my lord, then I have no case, my lord.
Are you? Would you want a rejection, or I can allow you to withdraw?
Really, nothing turns on this. Even if it's rejected, at least I'll have a say that I tried.
All right, issue. By consent of the parties, the appeal and the connected application are taken up for hearing together. Paragraph. The appellants are the defendants' money suit.
Yes, my lord.
In a money suit instituted by the present respondent in this court. Stop. The defendants, paragraph, the defendants applied before the learned single judge for rejection of the plaint, since according to them, institution of this suit in this court required leave under clause 12 of the latest patent, but such leave has not been obtained. Stop. The learned judge, the defendants so contended on the basis that the plaintiff has pleaded that the defendants carry on business both within and outside the jurisdiction of this court, the ordinary original civil jurisdiction of this, the ordinary original civil jurisdiction of this court. Stop. It has further been pleaded that part of the cause of action. Now, it has further been pleaded, it would further appear from the plaint that part of the cause of action has arisen outside the jurisdiction of this court. Stop. Therefore, the plaintiff ought to have obtained leave under clause 12 of the latest patent for filing the suit in this court. Paragraph. The learned single judge negated the contention of the defendants and dismissed the defendants, defendants' application for rejection of the plaint. Stop. The learned judge referred to clause 12 of the latest patent. Stop. His lordship observed that since the cause title of the plaint clearly mentions that the defendants also carry on business within the jurisdiction of this court, nothing further is required, and the plaintiff was entitled to file the suit in this court. Stop. Being aggrieved, the defendants have come up before us by way of this appeal. Paragraph. We have heard Mr. Anuj Singh, learned advocate representing the appellants, defendants. Stop. Learned counsel advanced the same argument which was advanced before the learned single judge. Stop. We are of the view, in agreement with the learned single judge, that if the plaintiff admits in the plaint that the defendants carry on business within the jurisdiction of this court, irrespective of where the whole or part of the cause of action arises, this court would have jurisdiction to entertain, try and determine the suit going by the clear words in clause 12 of the latest patent, 1865. Paragraph. Accordingly, we see no reason to interfere with the order of the learned single judge. Stop. The appeal and the connected application stand dismissed.
It will be your lordship's pleasure to record that the appeal is not maintainable because it's a commercial suit. It's an application under Order 7, Rule 11 for rejection of.
No,
the
Milord, that's debatable, Milord. That's on maintainability. I may, Milord, not concede here.
কথা বলছি তার আগে একটা মিস্টার সিং এর তার আগে একটা রেকর্ড করুন। Mr. Bhattacharya, learned senior counsel, representing the respondent oblique plaintiff, says that this appeal is not maintainable. Stop. This is a commercial suit. Stop. An order rejecting an application under Order 7, Rule 11 for rejection of the plaint is not appealable under the provisions of the Commercial Courts Act. Just record correctly. We are saying nothing on this.
Yes. Because this might create problems in subsequent proceedings, because this issue is debatable. I could.
I have to address your lordship, my lord. Yesterday, the entire evening, I was working on that.
Thank you.
And I think I have found an answer to that.
Very good. Yes, we'll be happy if you find an answer, because otherwise it's
the courts, because your lordship will see 13.1 says judgment, 13.2 says decree, because all decrees are not judgment. For example, my lord, your lordship, if I may trouble your lordship kindly takes the CPC once.
Not today. Not today.
Monday I will come.
But I came prepared to anticipating this argument. I was fully prepared to counter this argument. He did not raise it at the inception.
The right time. Item number 2.
Lordship yet not come.
Last.
Your lordship, some time is more required.
Who is appealing?
Advocate Gunjan Shah.
No, not today. Not today.
Your lordship, just
say one thing.
short pass over.
My account The appeal is yet to be admitted. I was just praying if I could get an opportunity to file an affidavit in opposition to
To what?
the application for stay, my lord. I know, my lord, it is
Junior counsel is appearing. Pray for that on. If there is no scope for interim order, we'll grant you that opportunity. He's the plaintiff. She's the
Yes.
plaintiff. What did she apply for before
but there was an application filed by me under Order 1, Rule 10 for deletion of the defendant number 4 from the array of parties.
that has been allowed?
That has been allowed. Appeal from there.
Commercial suit.
Yes, ma'am. Come on.
Is it an appealable order?
Kindly, it does not end.
Go into it. Look into it.
I intend to go into it because I did not open that book. Because
Just see. There may not be an appealable order. Look up Section 13 of the Commercial Courts Act, Order 43, Rule 1. Not today. Come back on Monday.
Oblige. Excuse.
If it's not appealable, no affidavit is required.
So that was, I did not want to open that in the absence of the senior appearing.
We have opened it.
Oblige. Excuse.
For hearing, item number 5 and 6.
You are for.
I'm appearing for the appellant in item number 6. Your lordship was hearing that on the last occasion. Please.
CS 1999.
Before your lordship goes through the paper book, may I just tell your lordship what is the appeal about? Milord, there are two defendants.
You are not in item number 5.
No.
Who is in item number 5? For national insurance? You are. Very well. Fine. Why 2 appeals?
There are 2 decrees, I think, from 2.
2 decrees. Very well. Similar suits.
Yes, similar claim. Insurance claim, separate insurance contracts. Claim was filed, claim was rejected. Contracts are different. Insurance contracts are different. Similar claims.
And in item number 6, there is a single marine cargo open policy. And the amount is fixed. That amount I shall point out. Plaintiff is Setia Oil, who was insured. The defendant number
Yes.
Defendant number 1
Yes.
is insurance company. And that kindly take the plaint. Your lordship will find the plaint. Kindly come to the paper book, page 3, volume 1.
Yes.
Setia Oil is the insured. National Insurance, the insurer, and number 3, Pritam Singh, is a transporter. Transporter didn't appear. I'm not sure whether I was not before the Honorable First Court. I do not know whether the writ of summons was served. Now, if your lordship kindly come to paragraph 4 at page 5 of the plaint of the paper book, volume 1. In the second and third line, your lordship will find that the plaintiff obtained an insurance policy from the defendant number 1, marine cargo per single insurance policy that has been annexed. And if your lordship kindly come to paragraph 5, there are 3 trucks or tankers. Kindly note in paragraph 5, they say that the 2 tankers of these numbers were not traced out. Last sentence of paragraph 5.
Yes.
Then kindly come to paragraph 7. It is in respect of the 3rd truck. This truck, kindly come to the last portion at page 5 or page 7 of paragraph 7. 3rd truck met with an accident. So if we
Yes.
In short, the 2 tanks could not be traced out and 1 tank
Met with an accident and the entire oil was lost.
Their claim is this much, 73,28,000 and not with interest. And again in paragraph 10, the plaintiff refers to the contract of insurance that their defendant number 1 is obliged to pay in terms of the insurance. So the limit should be considered. I shall come to that. So now I come to the broadly to the grounds. The survey report.
To the grounds of appeal.
Grounds of appeal on which.
That, Mr. Ghosh, it always helps us if you take us to the decree.
Yes, I am going to the judgment. Yes. I am going to the judgment.
Yes.
Before going to the judgment, I am pointing out one thing is favorable for the defendant number 1. The list of exhibits have been recorded in the judgment itself. And my submission is that the survey report, though it was disclosed in the judge's brief of documents, was not tendered in evidence as exhibit. Kindly come straight away to the judgment under appeal.
Which page?
Kindly come to page 199. Kindly come to page 204. The list of exhibit is recorded in the judgment itself.
Yes.
Now, my respectful submission is, Your Lordship kindly have a glance through it. There is no mention of any survey report.
This, we can always look up the records of the suit, whether it was
but what I am on, if a decree is passed, particularly in respect of the third truck which met with an accident, then the existence of the document is not the only thing, Your Lordship is aware. One has to prove the document, and even if a document is marked as an exhibit, that does not itself prove the document itself. Mere marking of a document, there are judgments to that effect, but here it is not even marked as an exhibit. And
yes,
who could have tendered the document? and prove the truth of the content thereof, the surveyor. The defendant, no witness came on behalf of the defendant. Adverse inference, whatever, that is there. But the document has to be proved by that person only. When I say document, I make three subheadings. One is existence of the document. Second one is contents of the document. And the third one is truth of the contents of the document.
Yes.
Now, existence of the document is not disputed by the party. Even they asked for the document and we have given them. The question is whether the truth of the contents of the document was proved.
Yes.
Fortunately, for the defendant number one, the document itself is not in the record, in the sense, not marked as exhibit. I again, my lord, repeating at the risk of repetition, mere marking does not mean anything. But when the judgment says that these are the documents which are tendered in evidence and proceeds on the basis of the survey report, presumably, my lord, on the basis that some questions were put in cross-examination to the plaintiff. That by itself will not absolve the plaintiff from its burden of proof. 102, in fact 101 to 104 of the 1872 Evidence Act, if there is no evidence on a particular point, the absence of evidence, in absence of evidence, whose case will fail, he has got the burden of proof. I just remind you, Lordship. So here, who has come in support of the third truck, which met with an accident? Plaintiff. This is one aspect. I am just pointing out. Second one is.
But the surveyor's report is your surveyor.
My surveyor.
So the report is in your custody.
It was my surveyor. They asked for it. By letter, I forwarded. I can't, my lord, overlook that thing. But will that mean that the truth of the contents of the survey report has been proved? That is the question. In my humble submission, no. I can put questions on many aspects in cross-examination. But that putting of questions in cross-examination by itself, unless one can show that this is the case of the defendant.
The surveyor was examined.
No examination of any defendant's witness, nor even the surveyor was called as a witness of the plaintiff.
Yes.
There could have been some ambiguity because in some suits hearing is done by not marking the document, but by marking the judge's brief of document, pages of judge's brief of document. Here, there is no such ambiguity because judgment says so. Second part is when I shall place the judgment and I shall formulate the point and point out to the judgment. The limitation. Kindly come to the plaint once. Kindly come to the plaint. You know, I was placing page 8 of volume 1. Kindly come to page 9.
Yes.
Paragraph 14. No party of cause of action is barred by limitation. Then paragraph 15 is very important. Between the period July 2006 to March 2008, the plaintiff has pursued the remedy under the Consumer Protection Act 1885 and ultimately by an order dated 31st March 2008, the National Consumer Dispute Redressal Forum has held that the plaintiff will be entitled to obtain benefit of Article 14 of the Limitation Act in the event it files a suit. Pleading is not proof. At least one has to tender in evidence the order of the earlier forum.
Yes.
Now kindly come to page 12, verification part for the date. 9th May 2008 is the date of, let us take actual date for it. Yes, filing of the suit. Not before 9th May, the suit was filed. Now, if your lordship kindly come back to page 7, paragraph 9.
Page 7, paragraph
9 of the plaint.
Yes.
Particulars.
Yes.
You will get all the truck details. I request your lordship, Lord, to write the truck numbers. It will be easier. First consignment is by WB03A C149.
Yes.
The second consignment is WB23A 4816. And third one is WB19A 3925.
Yes.
Now, first one is date is given 28/9/2003. Your lordship will get the exact dates in paragraph 5. First two consignments, two tankers, 28/9/2003 and 10/10/2003.
Yes.
And the third consignment was dispatched on 12 October 2003. That your lordship will find in paragraph 7 continuation at page 7, fourth line from top. The third consignment was dispatched on 12 October 2003. Insurance policy to dao koto pata hai. Your lordship will find that they have bar koro ekhan theke. 15, page 15, volume 1. This is the insurance policy. Total sum insured is 25 lakhs. Your lordship has got it in page 15.
Yes.
And after that, list per transit 12 lakhs.
List per transit, what does that mean? What does that mean? List per transit?
Means there are 3 trucks.
Yes.
For each, it is 12.
That comes to 36.
I don't know. That is, sorry. That is 25 total sum insured. Now, what has happened? What they have said is that total amount is 1320 in paragraph 9, 1370, and 1323. And for the time being, I'm omitting the interest part.
About 40 lakhs.
40 lakhs. And if one add the interest, it will be 73 lakhs. Now, so far as the 2 trucks,
the suit has been decreed for
the entire amount
73 lakhs.
73 lakhs. Kindly come to
Sum insured, if the sum insured is 25 lakhs.
Crores, not lakhs. 25 crores.
Oh, say so.
25 crores.
I must have something to say.
Now kindly come to the judgment under appeal. After giving the list up to page, my lord, 207, that is Exhibit X, the issues were, my lord, decided, and ultimately the last portion of the judgment. Kindly come to page 223. Last but one paragraph, fourth line, principal third and fourth line, please, sorry.
অনেক কিছুই দেখি আমি এখানে।
In, sorry, In view of my discussion and finding, page 223 of the judgment, middle paragraph.
223.
223, last page of the judgment.
Yes.
In view of my discussion and findings in the foregoing issues, issue number 9 and 10 are answered in the affirmative in favor of the plaintiff by holding that the plaintiff is entitled to a decree for a principal sum of rupees 40 lakhs, being the value of the consignment together with interest at 9%, etc. Now, there is...
You have deposited the entire amount?
Yes. Try to read. 60? কত? 60 lakhs. দেখো অর্ডারটা কোথায় দেখো?
So in this suit, your decree is for 73 lakhs. In the other suit?
A little less.
Little less.
So there is only one consignment.
Page 235, volume 2 is our order of the Honorable Appellate Court. Last paragraph, 60 lakhs.
$10,80,000.
No, 181 barcode.
Yes.
Now, kindly take, Milord, the deposition of PW1, page 81. Question numbers 128 and 129 at page 81 relating to Exhibit W. I shall place before Lordship Exhibit W. Mr. Gopinath Khandelwal was a PW1. 128.
Yes.
I am handing over you a letter, serial number such and such. Can you tell my lord who has issued this letter and to whom? This is a copy of the letter dated 10 July 2006 has been issued by the defendant number 1 to the plaintiff. Are the contents of this letter true and correct? Yes. Tendered marked as W. Now kindly look at Exhibit W. Page 181. Volume 2.
Exhibit W.
Yes. Letter dated 10 July 2006. Marine claim number such and such. On the basis of the documents submitted by you and the relevant survey investigation report, it has been without prejudice considered that such and such, etc., you neither informed police authorities regarding the lost case, nor initiate any legal action against the transporter. It is difficult to accept that the three tankers certified to carry the far less quantity of oil were carrying oil far in excess of the capacity. Therefore, we regret our inability to accept any liability under the three caption claim. However, if you can come back with the acceptable evidence duly certified by the respective authority that the tankers has the capacity to take the load as declared by you, the claim may be reviewed without prejudice for question. Now, kindly again similar at the risk of repetition, an answer to question number 129. PW1 has accepted the truth of the contents of this letter.
How can the author only can prove the contents? How can PW1?
No, if I write that you have done this, if I write to, I'm grateful, my lord. I was going to make submission. If I write to you that you have not done this, or this is the latches on your part, and he accepts. It's very unusual. We say only the author should come, that is the judgment only. And he should prove the contents. But if I say, I've given you 10 crore of rupees, and he says, yes, what is written there is correct. I may sound too technical, but if he accepts the case, this is the case made out.
This is Exhibit W.
This is Exhibit W. Kindly come to the list. It is written in the deposition, in the judgment. That was page. Exhibit W, your lordship will find item number 23 at page 207. And it is my duty to point out to your lordship, page 207, item number 23, Exhibit W. When I place before your lordship Exhibit W, it is my duty to point out to your lordship Exhibit X also, item number 24.
Yes.
11 July 2006. That your lordship will find at page 182. The 182A is the typewritten letter.
Yes.
So all the claims were before considering the survey report. Now there are broadly two aspects. 2 tracks were lost. There is no proof acceptable in evidence that any legal proceeding was initiated
against the transporter.
Against the transporter. Some proof. Yes, against the transporter in respect of the 2 trucks which were lost. So, loss of truck has to be proved, particularly when they have accepted the correctness of the contents of Exhibit W written by the defendant number 1. Firstly, it is the plaintiff who alleged that the 2 trucks were lost. It is burden of proof is on plaintiff. Secondly, it becomes more.
How will they prove?
At least they will say.
They have to say, yes.
These are the steps I have taken. কোথায় আছে? কোথায় আছে? ওখানে তো দেয়নি। তাহলে বলছো কেন? Usually, when a FIR is made after the police makes the investigation, a report comes, final report, that after inquiry we have found that 2 trucks could not be traced out. Something like that should be there. What they have pointed out, photocopy to the xerox copy একটা দিয়েছে নাকি? So, their claim on the basis of the survey, on the survey report could at best be restricted to the truck which met with an accident. And nothing more than that. Mere writing of letters, I claim this, he disputes, that won't prove the claim of the plaintiff as made out by them in the plaint. So I segregate or make 2 limbs of their claim, the lost trucks 2 and the truck which met with an accident 1. For the lost truck, I should say there is no proof to the effect that they have taken any step, legal step, to show that their trucks were lost. And for the truck which met with an accident, they have relied on, the judgment has relied on the survey report, when the judgment itself showed that it was not in evidence. ডিপোজিশন বার করো, হ্যাঁ এটা আমাকে বার করে দাও না কাইন্ডলি, সরি এভিডেন্স একটা দাও না। These are so well-known provision, but it's a bad habit of lawyers to show the provision.
No, please show, please show. 100.
Kindly come to first section 101 to 104. Evidence 74. এটাও আছে, বলে তো কোনগুলো দেখাও। 101. Whoever desires any court to give any judgment as to any legal right or liability dependent on the existence of fact, that is essential, which he asserts, must prove that those facts exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. So, if you assert some fact, you will have to prove it. Then, 102 is very important. the burden of proof in a suit or proceeding lies on the person who would fail if no evidence at all were given on either side. This, I will not rely most. Where there is total lack of evidence,
they could have called the surveyor as a witness.
Of course, in law, they are entitled to. If they have called,
Yes.
kindly don't take me amiss. There is a provision, section 165. Is the judge can put question.
In the
judge can put question, court can put question. These are between parties. Kindly look at how that section is also guarded. Section 165. Judge's power to put questions or production. (165). The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases, in any form, at any time, of any witness or the parties about any fact, relevant or irrelevant, and may order the production of any document or thing, and neither parties nor their agent shall be entitled to make any objection to any such question or order, nor without the leave of the court to cross-examine any witness upon any answer given in reply to any such question. Widest possible power. Then proviso 1. Provided that the judgment must be based upon facts declared by this act to be relevant and duly proved. That is the, I should say, the guideline.
There is a further curtailment of that.
In the next one,
the next one.
So, next one, second proviso. Provided also that this section shall not authorize any judge to compel any witness to answer any question or to produce any document which such witness would be entitled to refuse or answer, etc. etc. So 165 proviso, first proviso, I rely on before your lordship, just to emphasize that the judgment must be based upon facts declared by this act to be relevant and duly proved. Now here, in view of the chart of exhibits set out in the judgment, it is evident that this was not before the judge as evidence tendered. Existence of the document was not disputed because defendant number one gave that document pursuant to that letter. Will that by itself prove the truth of the contents without calling that witness? And there is no bar that they could not have called. If they called and the witness didn't come, adverse inference could have been drawn.
Why should I? I'm the plaintiff. I go before the court and say, my truck met with an accident. The entire oil was lost. And I claimed the insured amount. Company has not paid, therefore I've come to you. You, the company, do not adduce any evidence. My witness goes and from the dock deposes in support of the claim made out in the plaint. Why should that not be sufficient for the court? If you choose not to produce, why should I want to exhibit your document?
Grateful, man. I am making yes, yes. This is one of the, I think, to me, there are most difficult branches of law. I do not underestimate other branches. Are number one, equity and trust, dual ownership concept, and second one is evidence. Because every time I go through the provisions, another, I'm grateful. Just like Order 8, Rule 5, Sub Rule 2, undefended suit. Here, my letter, Exhibit W, 10 July letter, has been tendered in evidence by the plaintiff's witness, number one. And he has accepted the truth of the contents of that letter, which were against him, against the plaintiff.
That they'll have to explain. That letter they will have to explain. Acceptance of that letter.
Yes. So that's, I wouldn't have, my lord, ventured to make submission on this point. This is as simple as the proposition has fell from your lordship, which I told my landed, I say leaders. You did not adduce evidence through your witness. Why should the judge, kindly do not take me amiss, bother to look into what is written there in your letter? But it's just like kaleidoscope. With every turn, the design changes. But if the plaintiff accepts my contention prior to suit, kindly take Millard Exhibit W, keeping the question in your lord that was put by your lordship. Kindly take Exhibit W. One page 181. Kindly read the contents of the letter.
But again, you see, your client accepts that the oil was not delivered. This is the letter.
Yes. I'm on the claim. Oil was not delivered. Yeah, my client has said that the tanks could have is meant for less quantity. That had to be put by my client, proved. Because if I assert, you have taken 120, say, quintal, it is meant for 90 quintal, that onus would have been on me. Or I could have proved that on the basis of, I'm sorry.
We'll come back. Yes, they are asking you how long you will take. Just roughly how long you'll take?
Mr. Ghosh to say that he's a bit tired today.
Oh,
Insurance company.
he doesn't mind exactly. Can we release your friends or no? You will not continue for that long.
I don't think so because it is today is up to 1:15, I believe.
So will you keep us occupied till 1:15? This is what they are asking. Ki mushkil.
It will take some time, Milord. But for me, I think I want to get it abreast.
Even if you will start today, then they can go, Mr. Sen.
If your lordship permits that indulgence, then I'll prefer the next day. But otherwise, I can start.
If Mr. Ghosh continues till 1 o'clock, we'll rise after that. If let's say 1 o'clock, 1:05. We are not formally releasing, but you may.
Question answer গুলো দাও তো। Question answer টা। Photocopy.
Somebody was telling us you drive a ship these days, a very big car, which
They are.
Oh, I see. What is it? A Fortuner?
The color of the ship and is the same.
I see.
But it varies with the mood.
What is the color?
Color is black.
Black. Fortuner? No.
One is the Fortuner.
One is the Fortuner. The other is
I,
Mercedes.
they are more acquainted with these.
Wonderful.
Legs up.
সকালবেলা ঘুম থেকে উঠে যেটা মনে হয়।
No, the practical situation is whether it will rain or not.
Yes.
As the practical situation in Kolkata. We are I was making submission on page 181, letter dated 10 July 2006. May I just, sorry.
Sorry, yes.
And I am not in favor of reading out the judgment and reading out the deposition. That don't do.
We'll anyway go through it.
Now let us read this letter dated 10 July 2006. On the basis of the documents submitted by you, that is the plaintiff, and the relevant survey reports, investigation report, it has been without prejudice concluded that, then, if you kindly take the number 1, you neither informed the police authority nor initiate any legal action against the transporter. This is number 1. Kindly keep a note of it in respect of the 2 lost trucks.
Yes, but accepting that the cargo was not delivered.
Cargo was not delivered.
Right.
But that fact by itself, will that absolve the plaintiff? The provision from the provisions of law. The number 2, it is difficult to accept that 3 tankers certified to carry far less quantity of oil were carrying on far in excess of the capacity. Now this possibly, if I didn't, my lord, they have accepted it, but possibly this was to be proved by my witness. Fortunately for the insurance company, they have accepted the truth of the country. Then, therefore, we regret our inability to accept any liability under the three caption claims. Three caption means two lost, one met with an accident.
Sorry, again interrupting, Mr. Ghosh, but what passes through our mind
Yes,
is better we express it.
Yeah.
If the insurance company accepts that the cargo was not delivered, then doesn't the burden shift on you to show why the insurance policy will not be enforced in his favor? If the company accepts that the insured cargo has not been delivered to you or whoever the consignee is,
Now, let us look at the materials from that angle. There is pleading, that is a written statement of defendant number 1, and some documents tendered in evidence by PW1. Now, if
nobody has come forward from the side of the defendant number 1 either to prove the pleadings, the statements in the written statement, or anything. You say the contents of this letter Exhibit W now stand accepted. Insurance company also accepts it. The plaintiff also accepts it.
Before the suit. Before the suit, 10 July 2006.
Why do you say before the suit?
Date of the letter.
10 July 2006 is the letter.
Yes, and suit is filed in 2008. Right.
So the acceptance is by way of the evidence.
No. What I am on, this is not an afterthought.
No. We are not saying afterthought. What we are saying is that both the plaintiff and the defendant number 1, let us assume, as you are saying, accept the truthfulness of the contents of this letter.
My lord.
That would include the fact that the cargo was not delivered.
Number 1.
Yes.
If I formulate that, facts accepted by both parties, and the plaintiff and the defendant number 1. Cargoes were not delivered. Number 2, there was no information given to police authorities or any legal proceeding. No legal proceeding was initiated by the plaintiff.
Was it a term of the insurance policy that without such FIR, your policy will lapse or claim will not be payable? What is an insurance policy, Mr. Ghosh? You know that much better. We have all learned from you while in practice. It's a contract.
Yes.
So the terms of the contract will govern the relationship.
Now, if somebody comes and says there are two things possibly. The goods could not be delivered. That is one aspect. And the second aspect is goods could not be delivered on ground A.
That's probably the insurance company, it's the owners, to show why the policy will not apply, because the ground was accepted in the policy. The insured says, my good is lost.
Yes.
Your client accepts it. Yes. But says that maybe lost, but what have you done about it? You have not informed the police. You have not initiated action against the transporter. Are these two good grounds for you to avoid your liability under the insurance contract?
No. It is said that it has been without prejudice concluded. Till today, I am of course fail to understand what is meant by without prejudice.
Nobody understands.
So
that will be my advantage. Witnesses admitted. Nobody knows.
I only respectfully submit that what are the materials on record for this? They have produced a photocopy of a letter regarding loss of trust, right? No, এটা কি? Loss of trust না accident? এটা কি বার করবি? এটা বার কর। Kindly. What the plaintiff has relied on is possibly at page 139, Exhibit J. From the transporter to the defendant number 1, sorry, the plaintiff, your lordship will find the typed copy in the next page. Without examining the writer of the letter or any person on their behalf, the defendant number 2, this can't be, if that be the basis.
This is Exhibit J.
Exhibit J, that your lordship will find. কোথায় পাচ্ছ question? The relevant questions are question number 63 to 68.
Page?
Page is 67 to 69 of second volume.
Second volume? First volume.
Question first volume, sorry. Question is the first.
Question numbers, please tell us again.
63 to 68. Yes. Your lordship will find in the answer several dates of the letters are mentioned. The first letter dated 13/11/2003 starts at page 138 of the second volume.
One 33.
138. 138A is the typed copy. Second letter is that 17 November 2003 at page, type copy is at page 139A.
Then 25th November 2003.
Then 25th November 2003, your lordship will find that in page 140.
Sixth December 2003.
Then 6th December is 143. 143.
Hmm.
And at page 69 of deposition, your lordship will find that all were collectively marked as Exhibit J. Now, in the judgment, you at page 205, your lordship will find serial number 10 is Exhibit J. The descriptions are given there. Now, if your lordship kindly come back to 139A, 17 November 2003. A letter written by Amrit Transport to the plaintiff second paragraph says that they did not reach the destination. And third paragraph says, we confirm that we have received regular verbal inquiry over phone from inquiring about the fact of the above tanker, were also lodged a FIR at Barwan police station against the two missing tank owners, workers, lorries. It should be lorries. Please. Please, sir, acknowledge the.
Where is Jalgaon?
Maharashtra.
How long can it take for a tanker to travel? Huh?
That is what we have said here.
This is the tanker left at 28th September, 17th 11, which is almost 2 months.
Now, if they rely on this letter, and they have relied on, then the third paragraph of that letter mention of an FIR case has been there, but that has not been shown to the court.
Assume FIR is not there.
Yes.
Let us assume FIR is not there. They have not been able to show. Let us assume it's not there. Will that justify you repudiating the claim under the policy?
Under the policy.
Under the policy.
Well, I shall come to this when I place the insurance policy.
Sure, sure.
Now, in the judgment itself, your lordship will find, it is my duty to point out to your lordship, what are the conclusions on the basis of these documents. I am omitting the narration of facts, pleadings, and submission made. Kindly take the judgment. At page 207, the chart of exhibit. Issue number, I'm so sorry, Milord. Issues were framed. Those your lordship will.
Mr. Ghosh, these arguments will apply to both the appeals.
Yes.
No, I do not know about, because I am not.
The other appeal is different facts.
Well, that here were 3 tankers, 2 have lost, and the third is accident.
Yes.
There 1 tanker accident.
But otherwise all same.
Otherwise also.
Then why will you repeat argument?
In fact, the third tanker argument has to be the same.
Yes.
Accident.
In the other matter, survey report was examined. It was
Exhibited.
exhibited.
I see.
From where the learned single judge has come to a conclusion, like an expert, according to me.
Very well. There is a survey report on record in evidence.
Yes.
Very well. We'll consider that.
That report goes in our favor.
Now kindly come to page 203, the portion of the judgment where issues are framed. 203.
Yes.
Keeping in mind these issues, may I go to page 207 after the chart? Issues number 2, 3, and 4 are taken up together. It is well settled that the causes of action are bundle of facts in a suit. Insofar as the point of limitation is concerned, it is for the court to first decide whether the plaintiff's claim or any part of the claim is barred by limitation. The plaintiff has averred in paragraph 15 that in between period July 2006 and March 2008, the plaintiff has pursued the remedy under Consumer Protection Act 1885 and the National Consumer Redressal, etc., has held that the plaintiff will be entitled to obtain benefit of Article 14 of the Limitation Act in the event a suit is filed. The suit has been filed on 12 May 2008, so the suit is filed within the period of limitation. The plaintiff has an insurance policy from the defendant number 1 insuring the goods in goods were lost during transportation by defendant number 2. Hence, the plaintiff has cause of action against the defendant. The remedy pursued under the Consumer Protection Act cannot be a bar in the instant suit in the light of the leave given by Swan. The basis of this finding is the leave given, and that is only the pleading of paragraph 8. So this part is perverse, clearly. Even if I do not, even if I didn't file any written statement.
What if my witness goes in the box and deposes supporting the statements in paragraph 15? In the absence of any meaningful cross-examination on that issue or anything to controvert that, cannot the court act on it? Consider these. These are what are passing through our mind.
Yes. Otherwise, below section 76, I believe, the certified copy concept wouldn't have been there. Whatever your lordship pass order today, yes, at one point of time, the speaking to the minutes were there for lawyers. But as witness, when somebody comes, it is his duty to produce that document.
Have you denied in your written statement, paragraph 15?
Paragraph 15.
Otherwise uncontroverted?
Matter of record.
Matter of record.
Yes.
That is no denial.
No, matter of record means record should be there.
Anyway.
Matter of record does not mean, my lord, the paragraph, kindly keep a note, page 50 of paper book 1, paragraph 16 of the written statement, with regard to paragraph 15 of the plain, save and accept what are matters of record. All statements made therein are denied, disputed as if same are set out, reproduced herein and denied serially.
I remember my earlier days. These pleadings.
Yes. Now, I often tell my learned colleagues that don't write like this. Why? Which record you are not mentioning? They may bring a floppy, a record. So you must say records of the proceeding of that.
Yes.
I may not be happy with the language, but in the context of that, paragraph 15 of the plain, it must be the records of that proceeding. And the records of the proceeding can be proved by producing the certified copy under section 76, I believe.
All right.
Kindly have a look at section 76 of 1872 Act. Certified copies of public.
76.
Section 70. So when I say that privacy will appear from record, it implies in my most respectful submission, if you produce the record, meaning certified copy of the record, I'll accept. Because I cannot dispute that. Then I'll have to say in one or two exceptional matter, I was handed over a copy of the 5 judges bench's order, and I was surprised to see, I have not seen in my younger days, those 5 judges sat together. So everything is possible. But if someone produces the certified copy, that is the, under the law, court has to accept. Unless I can rebut that. This has not been done. I'm grateful because I really appreciate the queries from the bench. In some courts, I won't name them, the judges were smiling all along. The client lost because I couldn't get the opportunity of explaining or clarifying the queries that those were there in the judge's mind. So I can only submit this at the risk of repetition regarding section 14 exemption. It has to be done by this court on the basis of something. What is that thing? Not merely pleading, but the proof here. When I have referred to the records, in the legal sense, in the context of that proceeding, it should mean the certified copies of that final order. Now, yes, kindly come back to the judgment. I was placing page 208. So limitation point has been, the decision has been taken on the limitation point, particularly under section 14, is perverse in view of section 76 of the Evidence Act 1872, read with paragraph 15 and of print and paragraph 16 of the written statement. Yes. Then, my lord, issue number 7, second paragraph of at page 208 of the judgment. Regarding issue number 7, Mr. Swanso, the company secretary of the plaintiff's company, has deposed in the suit and proved on evidence the above mentioned documents as exhibit. He has stated on oath that the response to question number such and such, proving the insurance policy issued by the defendant number 1 in favor of the plaintiff, which is valid for the period from such and such to such and such, and it covers all risks, including SRCC relating to packaging, etc. Then, in answer to question number 16, he stated that since 1989, the plaintiff is getting insured to the defendant number 1, except for 3 years, during which time of insurance done from United India Insurance Company. Then page 209. The first and second consignments were dispatched on 28 September 2003 and 10 September 2003 respectively, which are lost and could not be traced as per the report submitted by the defendant number 2 transporter. Kindly note. The third consignment, so the report submitted by the defendant number 2 transporter is that letter. I'm not going into the technical, is that letter. So if that be so, whether it has been proved, that's the question. In my most humble submission, it has not been proved in accordance with law. Because they have in third paragraph has relied on something. And that person, the transporter, has not been brought by the plaintiff. So regarding first and second consignment, the report, kindly keep a note, report submitted by the defendant number 2 transporter possibly is the letter dated 17 November 2003. That's all. Exhibit J, part of Exhibit J.
Yes.
Then, the third consignment was dispatched on 12 October 2003. Therefore, I find that 2 consignments were lost and third consignment met with an accident as per report of the police. As a result, the plaintiff suffered loss in transit, which were duly covered by the insurance policy. Again, my lord, at the risk of repetition, 2 consignments were lost on the basis of this letter, whether or not it is proved. How can you say it is proved? It is really the belief of the honorable judge. On the basis of the document, it is proved or not. Before the appeal court will test whether it is legally acceptable. So, they are relying on something, a fact, which is the basis of the judgment. This issue regarding law. Because this will, that's why I submitted earlier that I shall come back to the query raised that you have not denied. You have said that the goods have not reached the destination. But if the case is built on certain facts, under 101, 102, they will have to prove it. If they will have to prove it, they have proved it, quote unquote, on the basis of this so-called report dated 17 November 2003 of the defendant number 2. Again, defendant number 2 was not called. And strangely enough, no records of that case has been produced here. So the only supporting document of the assertion that the 2 tanks were lost is this letter. Kindly keep a note of it. Then issue number 1, 5, 6, and 8. Maintainability of the suit, 209. Challenging the maintainability of the suit, Mr. Swanshaw, learned senior advocate of the defendant number 1, by inviting attention of the court to paragraph 5 of the plaintiff has submitted that there is no proof of the orders received by the plaintiff for the dispatch of such and such metric ton and such and such metric ton of the said oil to Marico Industries Limited on 28 September 2003 and also on 10 September 2000. This is a factual aspect. There is no averment as such made in the plaint as to when the 2 consignments got lost. It is submitted that this factual aspect of the case is required to be proved to show the genuineness of the claim made by the plaintiff under the insurance policy as to who placed the orders for dispatch of the consignment. The consignment generally reaches the destination within 7 days from the date of the dispatch. This is precisely the observation that fell from your lordship. So, there is an element of suspicion in the claim of the plaintiff for the reason that the report was not taken on inquiry from the defendant number 2 within proximate time, and that no such inquiry in respect of such loss of consignments was even made by the plaintiff. It is further pointed out that the plaintiff has not placed material evidence on record regarding contract for carriage of the consignments of 2700 metric ton on the said oil for transportation by the defendant number 2. It is stated that a third consignment was dispatched on 12/10/2003, but the plaintiff has not given any notice to the carrier or transporter claiming loss of the consignment. So those are the in respect of the absence of the evidence in the plaintiff's evidence or rather evidence adduced by the plaintiff. It is further argued by Mr. Swanshaw that the defendant number 1 being insurance company would be liable and responsible for the payment of claim of the plaintiff for the loss of goods in transit as per the insurance policy exhibit A only. And when there is no breach or violation of the clauses of the embodied in the insurance policy. Accordingly, the defendant number 1 has denied the contention as made in paragraph 5 of the plaint pursuant to the orders received, the plaintiff has dispatched the said consignment to Marico Industries Limited or to any other party by 2 tankers of the defendant number 2 bearing such and such number. It has been denied that the said consignments have been lost in transit and not yet traced out by the plaintiff. and or defendant number 2. It has further been submitted that the complaint regarding the alleged loss was lodged with the Bardwan police station after a time gap of 1.5 months of the incident, with no plausible explanation for such delay or lack of intimation to the defendant number 1. Mr. Swanshaw further pointed out that such conduct on the part of the plaintiff raises a suspicion as to whether at all consignments were so dispatched by the plaintiff through the transporter defendant number 2 hearing. It was also argued that no legal action is alleged to have been taken by the plaintiff against the missing consignment entrusted to the defendant number 2 for transportation of the said oil, and further that the tanker did not have the capacity to transport 27 metric ton of cargo, and as per report of the surveyor, there was gross negligence on the part of the assured, and the accident might reasonably be attributed to overloading the cargo in the tanker. It is argued that there has been willful misconduct of the plaintiff in not inquiring about the status of the transportation, and the tanker was overloaded beyond the capacity of tanker. Mr. Swanshaw invites our, my attention to exclusion clause 2.1, I shall come to that, of the insurance policy exhibit A, which provides that in no case shall the insurance cover loss, damage, or expenses attributable to the willful misconduct of the assured, and in view of the said exclusion clause, no claim of the plaintiff can be covered for any loss or damage, expenses, etc., for the reason of the misconduct of the plaintiff. The defendant number 1 is not liable for loss, if any, suffered by the plaintiff, inasmuch as the plaintiff could not establish his claim for the consignment of 27 metric ton of oil for transportation by the said carriage or tankers, as the capacity of tankers was not made known to the defendant number 1. He also argued that there has been fraudulent practice by the plaintiff when by one of its letters written to the defendant number 1, the plaintiff states that it is a standard market practice in India for transporter to have road tax by declaring low capacity of their tankers and trucks and carrying higher quantity of cargo as per their actual carrying capacity. Then page 212. It is further pointed out that the driver and Khalasi helper of the tanker were not inquired by the plaintiff, and no steps against the defendant number 2 taken, since clause 8 of the said policy for minimizing the losses is a duty of the assured, which has not been adhered to. Mr. Swanshaw advert to a reasonable dispatch clause 10. These clauses I shall place before your lordship. 2.55 and clause 10, relating to the avoidance of delay, which provides a condition under the insurance policy that the assured shall act with reasonable dispatch in all circumstances within their control, and argued that the defendant number 2, Omit Transport, has employed tanker WB such and such 3149 for arranging to load the cargo, but it has not named the driver of the vehicle and is undated. There is no signature on weighing ticket dated 28 September 2003 for loading 27800 kg by the said vehicle. It is revealed from documents Exhibit K collectively that the consignment was loaded on 28 September 2003 as per public weighing ticket. It is evident that a letter dated 7th October 2003, being part of Exhibit A, that Ashok Sethia, Executive Director of the plaintiff, wrote letter to the Omni Transport, which replaced the consignment refined rice bran oil to Jalgaon by tanker number such and such on 28th September, and tanker number such and such on such and such date were sent by the defendant number 2, but both the tankers have not reached their destination, although considerable time has passed since the date of dispatch of the tanker, and thereby the plaintiff sought for the information immediately about the latest position of those tankers. In reply to the said letter exhibited, the defendant number 2 informed the plaintiff by letter dated 8 October 2003, Exhibit C, that the said tankers were loaded on 28 September 2003 and 28 September 2003 respectively from Burdwan for carrying the said oil to Jalgaon, and 2 tankers were proceeding towards its destination. But till then, the said tankers have not reached the destination, and the defendant number 2 was trying hard to locate the tankers and assured the plaintiff that they will reach its destination very soon. Exhibit L relates to the comments carried by a lorry number such and such 4816, wherein Sharma as a driver has authorized for transporting such and such kg of the oil on 10th October 2003. As against this, Mr. Bose refers to the invoice cum challan being part of Exhibit M, where Avtar Singh driver has been assigned to assigned to drive the tanker number such and such in place of Sharma. I find from Exhibit M that the defendant number 2 entrusted Mr. Sharma for transporting goods by lorry number 3925 to transport 27000 kg on 12 October 2003. Invoice cum challan dated 12 October 2003, Exhibit M, reflects the consignment was to be carried by driver Jasbir Singh. So it is submitted that there is willful misconduct on the part of the plaintiff. By letter dated 22nd October 2003, Exhibit D, the plaintiff company called upon the defendant number 2 to inform the whereabouts and the latest position in respect of the consignment of the said oil by the tankers loaded on 28 September 2003 and 10th October 2003, 12 October 2003 from Burdwan for carrying the consignment to Jalgaon. But the tankers have not yet reached at the destination despite considerable time having been lost. In response to the letter dated 15th October 2003 and 22nd October 2003, the defendant number 2, Omrit Transport, further informed that they have sent their representative to trace out the 3 tankers, but no message was received despite the best effort, which fact is reflected from the letter dated 23rd October 2003 of the defendant number 2 and the letter dated 12 October 2003, Exhibit I, by the transporter to the plaintiff with regard to tanker number 3149 and 4816. Then 214. I am reading out this because the analysis of evidence and submissions have been recorded here. Later dated 15th October 2004, Exhibit 10, issued by the plaintiff to the defendant number 1, reflects that the plaintiff registered his claim for leakage of refined rice bran oil due to accident of tanker 3925 of Omrit Transport on 3rd November 2003, dispatched from Burdwan to Jalgaon. It further reflects that the final survey cum investigation report received from surveyor H.B. Ghosh, surveyor cum investigator Ranchi, loss due to accident was assessed as such and such. Now, on what basis, if I put the question to myself, if the chart is there, on what basis this is being recorded? 15 points must be from the judge's brief of document, and the documents were marked from the judge's brief, I believe. There was a confusion, I can say up to that. Otherwise, there was, when the Honorable Judge himself writes the chart of the exhibit, then this part is beyond the record of the suit. Kindly keep a note of this. When I say perverse, it has relied on something which is not on record. Maybe technically. The said surveyor was not examined by the defendant number 1. In reply to the said requirement, the plaintiff by its letter dated Exhibit N made it clear that following documents were submitted, such and such thing. Then, thus relying on the claim lodged by the defendant number 1 on behalf of the plaintiff, Mr. Swainso learned advocate has submitted that under the said letter Exhibit N, the plaintiff has sufficiently satisfied the condition of the claim of the loss recommended by the said surveyor cum investigator. However, it was not within the power of the plaintiff to produce the Pritam Singh of Amrit Transport. If I may put the question to myself, why? Have you made any attempt? There are ways and means. Summons could have been served as to come and depose as witness and produce the document also. That apart, in no communication, there is no communication by the defendant number 1 calling upon to hear the Pritam Singh. Now, this is, I think, this sentence, there is no communication by the defendant number 1 calling upon to hear the said Pritam Singh. Why should the defendant number 1 call upon the defendant number 2 to adduce evidence? If it was, it does not say so. If it relates to pre-suit correspondence, why should without tendering the document, maybe I am repeating, the judges will go on mentioning that as if that is on record, and the consequences are as follows. Thus, this is, I think, since it was marked, my feeling is it was marked from the judge's brief of document, and in the deposition there is mention, so it went through. I fully appreciate that in appellate court, it is here to criticize a judgment than to think in the light of the judge's mind. Possibly, I give that benefit of doubt to him, because I have myself done so many suits before him. Possibly it was in his mind that it is in part of the evidence. But if it goes, the route goes, the entire thing will go. Then, Mr. So-and-so brings my attention to a letter dated 17 November 2003 of the defendant number 2 to the plaintiff that an FIR was lodged at Bardwan police station against the missing 2 tankers with such and such, and a letter dated 25th November 2003 being part of the exhibit J to argue that the plaintiff wrote to the said surveyor in response to the latest letter including the Xerox copy of police report of Jaspur police station relating to the accident to tanker number 3925 along with copies of invoice, challan, etc., etc. Police report dated 15 November 2003 in Hindi with its translated copy in English would clearly reveal that the said vehicle met with a exhibit হয়েছে would clearly reveal that the said vehicle met with an accident in the midnight of such and such. It is my duty to point out, kindly take page 141 vis-a-vis this. Kindly have a look at page 141. after those bunch of letters. He won't say.
This 142 is the English translation.
Yes. We can always take it as an enclosure to the letter dated 25th November 2003 at page 140. Thus, it is argued by Mr. So that the transportation of consignment of tankers cannot be called in question, adverting to question number 219 and answer given by the plaintiff witness Gopinath Khandelwal in respect of the capacity of the vehicle, that it has capacity to load only 16600 kgs has been answered by the witness that it is the registered capacity but not the carrying capacity. Mr. Swanso on the issue of overloading relied on a decision reported in such and such, etc. Now the legal part comes. Now what I am on, if they put something extra, which is admitted by them, can they take benefit of this? It had the capacity to load only 16,600 kgs has been answered by the witness that it is the registered capacity.
You have to then point out a term in the insurance policy which says overload loading will be a good ground for your rejecting the claim.
Clauses I shall refer to.
Yes.
Which, according to
apparently there is a Delhi High Court judgment which was referred to by Mr. Sen, which says that overloading cannot be a ground for rejection of the claim under a policy.
Yes.
Cannot be a ground for rejection. That's recorded in the judgment.
Judgment. Now, then, my lord, judgments.
Later, judgment will come later. You proceed in your own way.
Now, kindly come to page 219. Page 219.
Yes.
Per contra, Mr. Swanso has argued on behalf of the defendant number 1 that there has been breach of contract of insurance which permits the insurance company to disown its liability to compensate the damage, if any, suffered by the plaintiff. I do agree with such submission, but it is well settled principle of law that if breach of a terms of contract of insurance so permits the insurer to complain of the breach, is required to prove that the breach of the terms of the contract of insurance has been committed by the plaintiff was claimed under the contract. It has been decided by the judgments above that in a situation like this, such complaint of breach of term would fail if the insurer does not lead any evidence. In the present case, the defendant being the insurer who claims breach of terms as discussed above has not led any evidence, but has attempted to prove its case by way of cross-examination of the plaintiff witness by inviting my attention to question number 142-219, the deposition of the plaintiff, to argue that A, the plaintiff had not done background verification on defendant number 2 and tanker. B, the plaintiff had not followed up the fate of the consignment in reasonable time. C, local authorities were not informed of the incident. D, no legal proceeding was initiated against the transporter. And E, tanker was carrying more than its declared capacity, which was not informed to the insurance company. I am unable to persuade myself with such submission. Plaintiff's letter dated 21st July 2005, Exhibit S, written to the defendant in such respect. He further submits that the defendant number 1 has not denied such statements and has not laid any evidence to the contrary. I think there is a repetition from par contra. Kindly keep a mark in your judgment. This par contra 219, is it there in a no? Then 220, Mr. Botran, so it may be a fact, 220 top. The plaintiff normally uses various transporters and dependent number 2 transporter was used for the first time in respect of the transportation of the said consignment. In this regard, Mr. Swansu submitted that the antecedents of the transporter was not checked by the plaintiff. Secondly, relevant statutory or other documents of the transport was not looked into by the before engaging it. Thirdly, no inquiry about the authority of omnibus transport was made. From the deposition of the plaintiff witness, I am of the view the plaintiff has acted like a reasonable man and answers of the plaintiff's witness that they had inquired about omnibus transport from other transporter and had checked the document at of the time of loading at the factory of the plaintiff seemed satisfactory and has not been controverted by any evidence on behalf of the defendant number 1. There does not appear to be any inordinate delay in registering the claim of the defendant number 1 or inquiring about the status of the consignment of the defendant number 2. And I find that the plaintiff has acted reasonably. This court has found that the communication between the plaintiff and the defendant number 2 are writ large to understand that the plaintiff very eagerly was inquiring about the said oil loaded on the tanker in question belonging to the defendant number 2, as the witness was has well answered the question number 175, that immediately after 15-20 days, inquiry was made from the defendant number 2. In this, repeated reminders were given to the defendant number 1 on behalf of the plaintiff to look into the claim made under the contract of insurance as reflected from letter dated 16th August 2005, addressed to the division manager of the defendant number 1, Exhibit S collectively and Exhibit R collectively. The chain so registered, the claim so registered with the defendant number 1 was in respect of loss of refined rice bran oil due to accident of tanker and left the two tankers, theft of the two tankers on transit. There is no dispute as regards accident of the tanker. No evidence has been produced to show that the other two tankers did not go missing, or that the tankers go missing is suspicious. It would appear from Exhibit T dated 9 September 2005 that the defendant number 1 called upon the plaintiff to produce the original of this certain document. The plaintiff, by his letter dated 30th March 2006, Exhibit V, called upon the defendant number 1 to settle the pending marine claims, informing that as marine insurers and its contract is collateral with the contract of affirmment as embodied in the consignment note issued by the carrier, and there has been no failure on the part of the assured plaintiff, and for which under the policy that defendant number 1 as marine insurer should be aware that in case of all risk cover, there is no onus on the part of the policyholder to substantiate the cause of the loss. This is precisely that fell from your lordship. That it is only sufficient to prove that there is loss and quantifiable loss by letter dated then the quantification part.
Mr. Ghosh will rise. When will you continue? This bench is not there after recess.
Yes.
This bench is not there. Monday? এটা commercial তো. Mr. Maloy Ghosh, learned senior counsel representing the appellant. opens his case but does not conclude. So paragraph, list this matter once again on Monday date the Monday date for further hearing. We new application পর দিয়ে দেবে আর কি হ্যাঁ হিয়ারিং এ এটাই ফার্স্ট হিয়ারিং ম্যাটার হবে রিজিনাল সাইডে কি খালি
My lord, may I be permitted to mention this matter, my lord, for inclusion in the list, my lord.
This bench?
This bench, my lord.
What, contempt?
Contempt, my lord.
ये तो दाओ तो
अच्छा,
appellate side list ये ওনারটা তো ওনারটা কোথায় Mr. Rajudri is here. Mr. Dasgupta. We'll first run through the appellate side list. So how long will you take? Give us a reasonable
If your lordship
estimate.
remembers, your lordship had asked them to come with a note, take
Yes.
5 minutes and file the
So
note.
if we take your matter up at 4 o'clock, should be sufficient? I mean, 3 o'clock. 3 o'clock.
I don't know whether they've got the note.
3 o'clock, half an hour we get.
This is what.
If you say, I will keep on saying try, Mr. Dashgupta, it's impossible.
At least, Miller will try to finish the math.
We'll do this. If we exhaust the appellate side, whenever we exhaust, we'll take it up. Otherwise, in any event at 3 o'clock, we'll take it up.
Whichever is earlier.
Whichever is earlier.
এটা কি লেখা হয়েছে আজকে কি লেখা আছে আগে অরিজিনাল বেঞ্চ হওয়ার কথা ছিল সেই হওয়ার কথা ছিল কম্পিটিশন সেই জন্য আছে 1 and 2 দুটা কি আছে আমাদের 4 নম্বর আইটেম তাহলে
My lord, the learned senior counsel, Mr. Alok Kumar Ghosh, is appearing in this matter, and I respectfully pray for short passover to enable his appearance, my lord.
The only thing, my lord, my affidavit in reply is to be filed. It is lying with my juniors, is yet to reach.
Very well. If you let us see the second call, we may not also take it up.
That's why today is 3:30, my lord. That's why I was.
What do you tell us? What do you want?
In that event, my lord, can you take next week or, my lord?
Then not today. Not today. Whose review is this? KMC's?
Yes, my lord. The KMC lose, my lord. KMC, my lords were pleased to observe that the KMC relevant document regarding service of notice could not produce.
Yes.
That was there, my lord. Subsequently, after vigorous search, my lord, the documents could be found out that the notice was served upon them. That we have, my lord. Then, my lord, the review application was filed with an application for condonation of delay.
We have condoned the delay.
No, but there is a direction for filing affidavit in opposition. There, my lord, I have filed my affidavit in reply. I have prepared my affidavit
So
in
this
reply.
requires hearing. This
Exclusive.
requires
Yes,
hearing.
Yes.
And Mr. Ghosh is appearing as my leader, my lord.
হচ্ছে না বাবা, হচ্ছে না বাবা।
Yes.
Not today হচ্ছে।
What? We'll pass it over or what? What shall?
So praying for passing over, my lord.
Or not today?
Mr. Ghosh is actually coming.
Yes, Mr. Banerjee says Passover is very uncertain when it will be. Not
So,
today.
Please, pass order not today.
Not today.
Number 3.
Lordship.
বলতেই পারে should I propose? Should I give you তোমার কাছে আসছে না মে মাসের এন্ডে সুপ্রিম কোর্ট ইয়ে করেছে নন পার্টিসিপেট আমি তখন আন্দামানে মনে আছে পোশাক পাল গুয়াহাটি সেই জন্যই তো নিয়ে আসার প্ল্যান সেপ্টেম্বরে তো বাঙালি প্রবাসী বাঙালি ভদ্রলোক নেক্সট জুন অব্দি আছে ইয়েস
Lordship, item number 3.
Yes.
Lordship, item number 3, Mrs. Deepjani Rai is appearing in the matter for the applicant. Lordship, she's before her legs before courtroom number 29. She requested me to pray for an adjournment on her behalf. Lordship.
Contempt.
Lordship, contempt.
We'll pass it over. Let us see. Next.
Lordship.
Matter Lordship, Mr. Sandeepan Banerjee is appearing on behalf of Howrah Municipal Corporation, Lordship. Kindly allow us a short passover, Lordship.
Passover. Passover.
Grateful, Lordship.
Item number 5, I am for the applicant one.
এসছে কেউ এক পক্ষ কি হবে ইয়েস ফার্স্ট টাইম নো
No, my lord. Serve upon the condemned, my lord.
ইউ সার্ভড
Yes.
রুল ইস্যু করবো দেখি না এলে হ্যাঁ যেটা দেখো
How you have served? How? Street post, my lord. Why is the
track report
track report? Track report is also there.
It was not fine. 2 minutes, sir. দেখো এগুলো না দেখে সরি আছে চলছি
মল্লিকা সাউ তো
মল্লিকা
চলো রুল রুল আর কি এসো কোথায় pursuant to our order dated May 2, 2025, a copy of the contempt petition has been served on the alleged contemptor as would appear from the affidavit of service filed in court today. Stop. However, nobody appears, however, paragraph the. However, nobody appears for the alleged contemptor. Stop. It seems that the alleged contemptor has taken court proceedings very lightly. Paragraph, there will be a rule as prayed for. Stop. Returnable.
Returnable, my lord, within 2 weeks, my lord.
এটা এটা দেখাই যাচ্ছে না এমন ভাবে রেখেছেন এটা
হ্যাঁ বান্ডিলটা নামাও বাবা নামাও ওনার মুখই দেখা যাচ্ছে না তো
আনন্দ লোক
রিটার্নেবল ওই 2 সপ্তাহ বাদে ডেটটা দাও না বাবা 4 সপ্তাহ 2 সপ্তাহ বললো তো 2 weeks
2 weeks, my lord.
রিটার্নেবল অন ডেটটা দিয়ে দাও একবারে নেক্সট the petitioners shall put in special messenger cost with the department within by Tuesday next to expedite the service of the rule on the alleged contemptor.
Yet, my lord.
List the matter, bro. Last week, list the matter on.
ঠিকই ছিল আমার তো মনে হয় খুব
সিঙ্গেল রিকোর্সের এমন একটা জুডিশিয়াল ডিসিপ্লিন তাদের রেফার করা উচিত।
আমি সেটাই ভাবছি ঠিক আছে। কিন্তু আমিও বসে যখন আমি যদি কোনো আমিও তাহলে তাহলে তো হয়ে গেল এটাই মানে
Item number 7 and 8.
So in terms of your lordship's leave, lordship, today I'm filing one affidavit. Lordship's order at page 34.
Yes.
Lordship's order at page 34 of my contempt application. Lordship, kindly allow me to read, start from page 35. Being aggrieved, the writ petitioner has come up before us. We see from the affidavit of service that the respondent municipality has been served, however, nobody appears for the municipality. The apprehension of the appellant is that since the chairman had issued the demolition order, going back to the chairman with a claim for compensation will be futile. We see some logic in such submission. Accordingly, modify the order impugned only to the extent that if the appellant makes a representation as she has been permitted to do by the learned single judge, the same will be considered and disposed of by the Board of Councillors of the municipality and not by the chairman alone, by a reason order in accordance with law within a period of 12 weeks from the date of receipt of the representation. After giving an opportunity of hearing to the appellant or her authorized representative, the order so far shall be communicated to the appellant within a period of within a week from the date of the order. We have not gone to the merit, Lordship. This was the order, original order. Now, Lordship, I filed initially a contempt application. That was CPN 252 of 2023. Now, this contempt application was listed before your Lordships, that is page 37. Now, Lordship, my learned senior friend appeared on behalf of the alleged contempt. Now, Lordship, in this contempt application was disposed of.
1 second. Yes.
Now, Lordship, kindly come page 38.
Yes.
Learned advocate for the petitioner says that although a direction on the Board of Councillor was to dispose of the representation within 12 weeks from the date of receipt thereof, and the representation was made on October 18, 2022, the representation is yet to be disposed of. Much more than 12 weeks have been lapsed. The alleged contemners have not complied with the order of this court. Mr. Chakraborty, learned advocate representing the alleged contemner, says that Kamini Bala passed away on October 18, 2022. She left behind 8 legal heirs, as would appear from a copy of the certificate issued by Mahesala Municipality annexed at page 16th of the contempt petition. Mr. Chakraborty says that the representation that had been made in the name of Kamini Bala can be disposed of in the presence of all legal heirs. Now, Lordship, this is relevant, Lordship. Learned advocate for the petitioner shall furnish address of all legal heirs of Kamini Bala to the learned advocate of the alleged contemner by 25th April 2023. Now, Lordship, kindly come the next line.
The Board of Councillors shall issue notice of hearing to all the legal heirs of Kaminibala, even in spite of receipt of notice. If one or more legal heirs fail to appear at the hearing, the Board of Councillors will still proceed and dispose of the matter. The legal heirs who appeared before the Board of Councillors will be entitled to rely on relevant documents as they may be advised. The Board of Councillors shall take a reasoned decision on the representation that is pending before it. Needless to say that if the Board of Councillors comes to the conclusion that compensation is payable to the legal heirs of Kaminibala, the same shall be paid as expeditiously as possible, but definitely within a 12 weeks from the date of the decision to the legal heirs in equal share. The Board of Councillors shall decide upon hearing the legal heirs of the Kaminibala who choose to appear before the board or their authorized representative. The entire exercise shall be completed within a month from the date of supply of this address of the legal heirs of Kaminibala by learned advocate for the petitioner to the learned advocate for the alleged contender. Now, Lordship, in terms of the solemn order, kindly come page 41, 25th April 2023. Lordship, I have supplied all the names of the heirs of the deceased Kaminibala. That is, page starts from page 41 to the learned advocate appeared on behalf of the alleged contender.
Yes.
Now, Lordship, page 44, on 10th May 2023, the chairman issued a notice upon all the heirs.
When, sorry?
That is page 44 on 10th May 2023.
Yes.
Now, Lordship, hearing was fixed on 17th May 2023 at 1 p.m. Lordship, on that particular day, the petitioner and the concerned learned advocate could not appear. Lordship, prayed for time and Lordship served Lordship, the letter. That is page 45. Now, ultimately, Lordship, on 6th June 2023, Lordship, the concerned chairman, Mahestala Municipality, again served a notice. The date of hearing was fixed on 12th June 2023 at 1 p.m. Now, in terms of this notice was served in terms of the contempt of 252 of 2023. Lordship, I appeared. Now I appeared and Lordship submitted a written notice of argument. That is 26 June 2023. Lordship, my written argument starts at page 48. Now, Lordship, written argument Lordship was submitted. I represented on behalf of the all Lordship the heirs. Again, Lordship, on 7th August 2023, that is page 65.
Yes.
Subsequent notices served. To attend in the hearing. Lordship, page 68, I submitted a reply that already replied to that effect. Page 68, my reply to all these notices, that already whatever my submission I have submitted through my written notes of argument. And Lordship, I requested them to consider my written notes of argument and pass a reason order. Now, Lordship, this is the letter of 11th September I also requested. Now, Lordship, the concerned alleged contemptor filed a affidavit. Kindly come the affidavit of the alleged contemptor. Paragraph 4.
Hey, Baba, কোথায় আছে দেখো?
It was affirmed on 2nd day of May 2025. Yes. Learned advocate, Mrs. Mohana Das.
না কোথায় ওনারটা কোথায়? না না ওটা হচ্ছে রিপ্লাই টু দ্যাট। Yes.
Lordship, kindly come the Lordship, the paragraph 4, first 3 lines. It is further submitted that in the first contempt proceeding, that is CPN 252 of 2023, we did not receive any notice of the contempt application and were therefore unaware of the said proceeding, second contempt application bearing such and such, such and such. So let's say first contempt application on oath, they have stated that no notice was served and they had no knowledge.
Application was not disposed of in their presence.
Yes, I have, let's say, pointed out that learned advocate for the
At-
alleged contemptor was present. And let's say all these notices relying upon CPN 252. Kindly come to the again notice, page 46.
Insufficient, Mr. Chakraborty.
I may be allowed, my lord, to add on the last occasion, Lordship directed us, my lord, to file an affidavit. We have filed it, and my lord, a date was fixed.
No, which one? The 2nd of May?
Yes, my lord, the affidavit we have filed.
Yes.
Here, my lord, page 6, my lord, on 28/5/2025, my lord, before the Board of Councillor for adjudication. What is our difficulty, my lord? Kaminiwala died in the year 2022. For a considerable period of time, for the reason best known to them, they did not disclose it. Thereafter, contempt file, this Honorable Court directed them to substitute, and substitution has taken place. And then, my lord, the difficulty was at that point of time, since Kaminiwala was not there, and subsequently, my lord, taking the name of all legal heir of Kaminiwala, my lord, we have sent notice. Only one person is appearing before the Board of Councillor, and the other thing is the learned advocate, he is writing letter repeatedly addressed to the, my lord, the Mohestala municipality without indicating who are their client. That being the situation. The thing is this, my lord, the actual thing is, my lord, on a vested land, this property was there. This is not their land.
Mr. Chakraborty, all we want is an order, a reasoned order.
Possibly, my lord, this is my shortcomings. On 28/5, my lord, is what taken up, 28/5/2025 was taken up by the municipal authority, Board of Councillor. My lord, they can, my lord, throw, this is my fault on my part.
They have made it clear that they have said whatever they wanted to say by filing written notes.
Any order they have received or not, my lord, that is to be, my lord.
No.
It is an order.
So there will be a rule.
28/5/2025.
So there will be a rule. Come. We have gone through the affidavit. And what is the statement, Mr. Chakraborty? Not your statement, your client's. We did not receive any notice of CPAN 252. How did learned advocate appear then?
No, my lord, at the outset, my lord, when the matter appeared in the list on some occasion to save.
No, that is not what is stated here.
That is for to save the contemner. Sometime
This is perjury, so we'll direct initiation of criminal proceeding against him also.
sometime we appear along with the, my lord, the
Rule
prayer,
to issue করুক আগে আসুক.
let a copy be served to us, and my lord will come back. That being the situation, possibly, my lord.
Affidavit filed on behalf of the chairman of the Mohestala municipality. Stop. There isn't any acceptable explanation as to why the order in question has still not been complied with. Stop. Paragraph. Further, comma. A palpably false statement has been made in paragraph 4 of the affidavit to the effect that the deponent of the affidavit did not receive any new notice of the contempt application being CPAN number 252 of 2023. Stop. That this statement is not true will be borne out by the fact that learned advocate appeared for the deponent in those proceedings. Paragraph, for the time being, now, paragraph, now we can't we will consider the issue of initiating criminal proceedings for perjury against the deponent of the said affidavit affirmed on 20th May or 2nd May?
So may I be permitted, my lord?
2nd May.
May I be
May
permitted
2, 2025. Stop. For the time being, there will be a rule against the chairman of the Maheshtola municipality being the respondent number 2 in the contempt application. Stop. The rule is made returnable 2 weeks.
Plus.
2 weeks we say ওই তারিখটা করে দাও তারপরে special messenger cost. Mr. Chakraborty,
may I be permitted?
you may be permitted once he comes.
My lord, he will come. My lord, definitely court is, my lord, directing him to come here.
Yes.
Only, my lord, the observation made at this juncture, my lord, can you allow me to go through all the things, my lord? And then, my lord, this prima facie observation may, my lord, cause, my lord.
Yes, may cause a lot of difficulty for him, which we want.
Since it is prima facie, that is why I am patient, my lord, making this.
What prima facie?
I am making this
in black and white. He has written.
My lord, the rule, my lord, lordship issued. But so far, this observation is, my lord, I intend to, my lord, make this submission. Kindly allow me, my lord, to come back along with, my lord, our explanation in a more effective way, my lord, to give, my lord.
He is not fit to be the chairman of a municipality if he can't express himself. What he has said is quite clear.
Lordship knows, my lord, we people are also responsible. I am not blaming him only. But if this honorable court fix responsibility, I am to take that.
No, why? Why should you?
Because, my lord, while, my lord, drafting it, we used to place it and they used to sign it, almost going through it. At the same time, my lord, this is our mistake also. I should also
Unfortunate.
confess, my lord, before this honorable court.
Unfortunate.
I do admit, my lord, that being the situation. That is why I am asking for, my lord, praying that particular portion, my kindly please keep it up. Keep it up. Keep it up.
ওই পোর্শনটা কেটে দাও তাহলে
Keep it up.
ওই পারজুরি ওইটা ওই ফার্দার ওই স্টেটমেন্ট
Must appear personally.
এত রুল যাচ্ছে রুল তো পুরো আসতেই হবে বুঝেছো কোনখান থেকে কাটবে হ্যাঁ ওইখান থেকে কেটে দাও খালি রুল করে দাও
Keep it up.
My lord, I am for the petitioner advocate praying for not today, my lord.
This is that matter. I have not heard that.
Remember Mr. Arindam Banerjee.
Yes, no, it has now been complied with demolition, executed.
They are not there. What can we do?
I don't know.
Come back 2 weeks hence. We'll sit again 2 weeks hence. Accommodation is prayed for on behalf of the petitioner. Paragraph. Learned advocate for the respondent numbers 3 and 4 says that demolition of the concerned structures have been completed. Stop. That's what you said. 2 and 3. I said 3 and 4. Yes, I said 3 and 4. Paragraph lists this matter once again 2 weeks hence. শোনো যেটাই হবে অ্যাডজান্ট 2 উইক পরে করে দেবে একই ডেটে দিয়ে দেবে আছো তো
My lord, we are for the petitioner. I am appearing on behalf of I am appearing as respondent number 11 in person.
Respondent number 3, 5, 6, 7, 8, 9.
My lord, this case, my lord, involves your lordships while sitting with the then Honorable Chief Justice Pattathil B. Radhakrishnan. Then, my lord, your lordships passed an order. That order was, that means that there was serious miscarriage of justice and a man has been put in prison for more than 93 days because of such and such acts. And the court means that passed the order, let stay all the proceedings Till then, no one should be done this. But in the meantime, having knowledge of all these facts and in presence of both sides, all the parties, they were present at the relevant point of time, when your lordships be sitting with Honorable Chief Justice, they then pass the order. Therefore, it is expected and desirable they will do according to the letter and spirit of the Honorable Court's order. And it was highly expected when they are holding different important positions like the judicial officers as well as the public prosecutor of the district and for those who are representing there at that point of time, private parties means a advocate, and at the same time, the concerned advocate of this Honorable Court, who was also duty bound to communicate it. But thereafter, everything happened more worse than the situation was. And the record will speak for itself. Under compulsion, we have filed the contempt application. That contempt application, prima facie, was allowed, and your lordships are pleased to issue rule. And on the basis of the rule, your lordships further directed that there will be exchange of affidavits. In the affidavits, my lord, that they have made their submissions, we have made their reply, narrating everything how it has been done. Now, my lord, that when it is the onus cast upon them, let them say that how they will be exonerated.
Mr. Odhikari, we'll tell you something. There are a number of affidavits which have been filed because there are a number of contemnors. Allow us to go through these affidavits. We'll come back on the 25th. So if we come back ready ourselves, it may take less time. তাই তো এগুলো আমাদের পাঠিয়ে দাও বাড়ি নিয়ে যাব লেখো after issuance of rule all the contemnors have filed affidavits.
Yes.
Comma, all the alleged contemnors have filed affidavits in response. Stop. Paragraph. Today we have briefly heard Mr. Odhikari, comma, learned senior counsel appearing for the petitioner. Paragraph lists the matter once again on July 25, 2025, when this bench proposes to assemble again. গুছিয়ে এগুলো affidavit গুলো ঠিকঠাক করে আমাদের
I am appearing for contempt number 1 and 2, my lord.
Oh, you are there.
Contempt 1 and 2, my lord. I have already filed my affidavit, my lord.
Very well. Very
Lords.
I am deeply obliged.
My lord, kindly recall this order was passed on 12/4/2023. Lordship directed Murshidabad administration to publish, my lord, the result of the assistant, executive assistant and other assistant post within 6 months. That is, my lord, 12/4/2023, my lord. The whole process to be completed, none other than Advocate General assured this honorable court. Page.
1 second, Mr. Chakravarti.
Initially, my lord, they took a plea before the single judge. Every record is missing. Then this honorable court intervened. They come forward with a plea. It is there. We intend to assess it. At that point of time, Panchayat election.
By June 30.
I know, Lord. By June 30, Lord, we have already taken, Lord, interview of all the candidates. There was a mistake. Mistake in the sense, Lord, by way of an affidavit, I am clarifying that there were, Lord, 17, Lord, exempted candidates who were supposed to be interviewed. In the meeting held on, Lord, 26th of June, Lord, we found that these candidates, they have been omitted from the list. So we issued a notification invited them for Lord the Viva Voci. It is over on 2nd of Lord July. I prayed Lord in the affidavit, Lord by 25th, Lord it will be over.
25th of July.
Yes.
We are assembling again on that date.
Lordship.
We had
On affidavit, Lord, I have
One
stated
thing,
that.
my lord, I intend to draw lordship
And
attention.
Lord, the progress, Lord, what has happened in the meantime, Lord, I have all narrated here in the
We'll
affidavit.
take that on record.
But
We also wanted to know from you, Mr. Mukherjee, whether the present petitioners,
But excepting
One of
one,
them-
Lord, others are not there.
others are not there. One is there.
One.
narrowly saved, my lord. My lord, I intend to draw lordship attention. The mistake which they have committed, they did not indicate in their list that who is scheduled caste, who is scheduled tribe, who is OBC, who is exempted category. We preferred one separate writ application, writ dismissed, and appeal court, my lord. There are certain direction, as a result of which now they are inviting some person, and some of them, my lord, my lord, the trying to, my lord, file the appeal, my lord, and proceeding the appeal, my lord, as appellant. So, my lord, they are, my lord, categorically trying to, my lord, conceal every material fact. When we are trying to hammer them, they are adding 1 or 2% from that particular list. That is happening, my lord. That being the situation.
Hammer is made of what?
My lord, hammer, my lord, drawing lordship attention.
No, iron, no.
No, drawing lordship attention. Sometimes I'm sorry to say, my lord, the magistrate, district magistrate of Murshidabad is not in a mood to, my lord, adhere to the direction of the honorable court.
The weather is such. Look at the sky.
My lord,
Come back on the 25th.
I have faced, my lord, court anger just now, my lord. It's still in my.
That's all mock anger. You know that.
Not, my lord. I have never seen, my lord.
You have
Lordship
known
has
that.
taken serious exception. It's my responsibility.
Affidavit filed on behalf of
Contender number, alleged contender number 1 and 2.
alleged container numbers 1 and 2 in court today. Be kept with the records. Give him a copy.
Yes, sir. Thank you.
Stop. Paragraph, Mr. Mukherjee, comma, learned senior counsel representing the alleged contemnors, says that in the affidavits filed today, comma, his clients have indicated indicated all the steps that have been taken so far. Stop. All the relevant candidates have already been interviewed. Stop. The result will be published by 25th.
So that is at paragraph 15 of my.
Stop. In paragraph 15 of the affidavit, it is stated that the result of the selection process should be published by July 25, 2025. Stop. Paragraph. List this matter once again on July 25, 2025, when this bench proposes to assemble again.
Once again, my lord, I'm taking this last chance. My lord, lordship knows one judgment was there, my lord, OBC related judgment, 7%, 17%. My lord,
division bench, yes.
Division bench judgment, which has no stay has been granted by the Supreme Court. They did not, my lord, indicate the who is SC, who is SC.
Advertisement is published prior to this.
Maybe, my lord, one paragraph is there, settled thing not to be unsettled. The selection process was not completed.
Advertisement was
true, my lord. On the basis of advertisement, everything will be decided.
You know.
Deeply uplifted.
Although I am appearing on behalf of the alleged contempt number 1 and 3, my lord, in pursuance of your lordship's direction, my lord, already, my lord, area pensionary benefit is concerned, the finance department has already been sanctioned.
Who then gives them?
This is also my instruction also, my lord. Already I have not handed over yesterday, my lord. They just shown me that they have sanctioned 16 lakhs so far as the state's part of the contribution is concerned. And so far the municipal parts concerned, my lord, I think municipality is not in the proceedings. But as we are the state machinery, my lord, at least they should at least make it a time-bound affair so that I can at least receive the entire area within a certain period. If their lordship kindly, because state has done his job. So, but the municipality 60% is.
It was the.
Why did you not implead municipality? They were not parties to the writ petition.
They were parties, but they have not.
It is arising out of the state part, my lord.
Arising out of?
State has preferred an appeal, my lord.
State and director local bodies.
But municipality is a party.
The,
In the contempt, you have not added the municipality as a party.
I have not added.
So how can we pass any direction on them?
Can you grant me a time I have to add them a party in the proceedings? Leave may be granted so that I can implead.
See that they can accept this proposition.
I will accept, my lord, but
No, no, no.
municipalities.
Municipality may accept their proposition that they will pay the half of the. Wait for some time.
ভাবছি কি করবো?
We have to dispose of the matter.
Actually, kindly at least stipulate.
We will direct the municipality, even if they are not parties.
Make the payment within a certain period of time.
If they don't obey, then you come with the contempt against them. What can be done? Whom should we add in the municipality? We want to add some officer. Chairman.
Chairman.
Which municipality?
Dom municipality.
The chairman of the North Damdam municipality is added as a party respondent to this contempt application. Stop. Mr. Shaptoshi Rai, please listen to us. Listen to us.
Man, it's not North Domdom, it's South Domdom.
South Damdam, South Damdam.
Oh, only Domdom municipality.
Only Damdam. Added as a party respondent in this contempt application. Stop. Learned advocate on record for the petitioner shall carry out appropriate amendment to the cause title of the contempt petition in course of the day. Paragraph, learned advocate for the DL, Director of Local Bodies. No.
on the behalf of the finance department.
State. On behalf of the state, produces a memo dated June 16, 2025, whereby
Finance department.
the finance department of the state government has
Endro Singh, chairman,
sanctioned the state's share of the pension payable to the petitioner. Stop. Let a copy of the memo be kept with the records. Paragraph. We direct the municipality to take all necessary steps so that the petitioner receives his pensionary benefits within 2 months, 8 weeks. 8 weeks from the date of communication of this order to the appropriate authority in the municipality. Paragraph, no useful purpose will be served by keeping this contempt application pending. Stop. CPAN or what?
Yes.
Are dao bhai ekbar. Rule was issued.
No.
We CPAN, CPAN stands disposed of.
Grateful, man. Actually, leave me be granted to correct the cost by incorporating the name of the chairman.
We said so. Appropriate amendment to the cost title in course of the day.
The same instruction was given by the DLP also. The state has given the instruction.
Then not necessary. Madam, keep it.
Harendra Singh, chairman, Domdom municipality. Grateful.
লেখা হয়েছে সব হয়ে গেছে
এখনো শেষ হয়নি এবারে মিউনিসিপ্যালিটি বলতে আমার টাকা মনে নেই সে একটা
ভাই নট হেয়ার লেখা ছিল তো। Originally file was not here, but so it was marked in the list.
What? The MAT file is not here.
I am ready with the affidavit.
Lordship is looking at a Lordship's order of 2nd May, I believe.
I am
2nd
ready with
May
the
2025. No, my lord, no.
You appear for the petitioner.
Yes, it's my application.
I am ready with the affidavit.
Affidavit.
Affidavit is being filed. We are ready to be served a copy.
They have not served a copy?
No, not yet.
You have, so you have not filed your reply?
No, my lord, I couldn't. I'm just now received the copy from Milan.
So file your reply.
Yes. But
Last page of the affidavit there is that we have already
the
started.
question is, my lord, when they are going.
Mr. Banerjee, the order was passed on when? 10th May 2023, and 1 month's time was granted.
Yes.
For shifting. And if not shifted, you were to demolish.
I started demolition.
When did you start? 2 years have gone by.
That is
1 week. Lord, I have certain submissions. Lord,
Who are you?
Lord, I am not a party in this process.
Yes.
Lord, I do not have any right of audience, but Lord, only it is a mercy plea with which I am here. Lord, my difficulty is I am the tenants of this house, including tenants who were tenants prior to the house was built. Lord, will only listen to me for 1 minute. Lord, the situation is this property was a Thika property. Lord, the petitioner went up before the LRTT for cancellation of the order of Thika. In the meantime, the petitioner invited the developer for a development agreement. Development agreement signed, and a building was supposed to be created. Before the building started being built, the Thika was cancelled.
So declared to be not a Thika tenancy property.
Allowed the application of the petitioner, and the petitioner won. The Thika was no more a Thika land. Then the developer builds a house which was built without the sanction plan. We as tenants has no role. Neither we were parties in the development agreement, nor we were taken into confidence while the building was built and how it was built. Thereafter, we were accommodated in that building. In the meantime, the accommodations were given. Now, we are not parties in any of the proceedings. And the demolition have started, we are still staying there. Nearly 100 of tenants are there in the entire house. My humble submission is, I can show it from all the records also, that the ploy of the petitioner and the developer is, in a very smooth manner, they have gone by the process of law to evict us.
Mr. Nag, as you rightly said, you have no right of audience. We have heard you for more than 2 minutes. Yes.
We filed a writ petition. In the writ petition, the Honorable Single Judge had directed the municipal corporation not to proceed with the demolition for 10 days. Thereafter, there was a modification application. Stated they are not interfering with the order passed by the Honorable Single Bench. Now there is an appeal. The appeal is listed before Justice Mantha, the division bench there, because that bench presently has the determination. While taking the leave of the court, it was making a specific submission, that the similar proceedings has been pending before this bench. My humble submission is, even the municipal corporation, until and unless this was listed, this contempt was listed, did not issue a second notice that on 14th they will demolish. My humble submission is only small submission, that let that appeal be heard by this bench. We have made that submission. Or my Lord Justice Mantha is not available for the 2 days, that's why we could not get it listed here. We are in that difficulty. We cannot get it released.
Do whatever you can do. We are only listing this again on the 25th of July. In the meantime, Mr. Lahidi's clients will be at liberty to file affidavit in reply. Do whatever you can do in the meantime.
Of this order. So we are not stopping them.
We are not saying anything.
There is another issue.
Does it comment to your lordship to issue a rule, Milord?
Against the municipality, Milord? Not today.
Not today.
Let us see on 25th. Let us see how far progress, progress they
as
make.
far as submissions to my land is 20.
We are not taking any.
No, I tell you, lordship, only this, Milord. A similar prayer was made my lord, in a proceedings and went up in
You
appeal.
are who you want demolition.
Yes,
Who are you?
my lord, I'm the landlord.
So you build the house.
No, I didn't.
I am for the developer. I have
I've
voted
got
the
no
con-
part in the building, my lord. This entire, my lord, six-storied building, this entire six-storied building was raised without any sanction plan from 1 to 6.
We come back on the 25th.
On
Mr.
25th.
Lahiri. Affidavit in opposition filed on behalf of.
One more point. Millard had directed for a stability report. The municipal corporation came up and said that they have floated a tender, but nobody is interested to check this.
Well, that we shall see on the
Without
25th.
stability report. That was how the demolition is taking place.
So now he's questioning demolition.
Nag, please appreciate this is a contempt application.
The order is there.
How can we go behind the order? Challenge the order with the Supreme Court. Have it set aside.
Not want to. Millard, what we
Your
want to
wanting, not wanting is irrelevant.
appeal which we want to get heard by.
This is a very favorable plot, I mean, of the developer.
Filed on behalf
Set up
of the alleged contemnors, we kept with the records. Paragraph. Now, okhane likho, a copy of the affidavit has been made over to learned advocate on record for the petitioner. Stop. Paragraph. List this matter once again on July 25, 2025, when this bench proposes to assemble again. Stop. In the meantime, the petitioner will be at liberty to file his affidavit in reply with advance copies to learned advocate for the alleged contemnors.
Lord,
And
I
in the
am for the
meantime,
developer,
Milord,
my lord.
gives leave to my learned friend, Milord, to amend the cost title, because already, Milord, order was passed by Lordship to implead the commissioner. Milord went to the department to amend the cost title, Milord. Department said, when the matter is placed in the court, then you do it. So therefore, the file was not made available. The file is today before a Lordship, Milord. Milord, and 2nd May 2025 order,
I cannot.
2nd May, Milord, order
Yes,
was
yes,
passed
yes,
to
yes.
implead the commission. Lord,
Lord,
you can see
only
the first
humble
paragraph,
prayer,
Milord.
my lord.
Let my learned friend given the liberty to include the name of the commission. in the
Uh,
cost title. I mean, that the file be made available.
Yes, his
File be
learned
made.
advocate on record for the petitioner is granted liberty to add the new incumbent in the post of Commissioner, Howrah Municipal Corporation as respondent in the contempt petition and to carry out necessary correction in the cause title of the contempt petition.
My lord, only humble prayer, my lord. I am for the developer, my lord. Let the time for filing the opposition on behalf of the developer be extended, my lord.
You are one of the alleged contemnors.
Yes, my lord. Contempt number
He's a
4.
party.
Yes, my lord. Party.
Yes. Developer is
Why haven't you filed till date?
My lord, they have filed several writ petitions, my lord. The tenants over the building, my lord.
Then you file within a week.
Yes, my lord.
And then you file your replies by the 25th. তাহলে এক কাজ করো হাওড়া কর্পোরেশনটা নিয়ে নাও, হ্যাঁ, নিয়ে যেটা বলেছি কি বলেছি লিস্টিং করো না এখন। The petitioner will be at liberty to file his affidavit in reply to the affidavit in opposition of HMC before the next date. Paragraph. Learned advocate for the alleged contempt number 4 seeks extension of time to file affidavit in opposition. Stop. Let such affidavit be filed by আজকে কত তারিখ
11th of July.
by 18 by July 18. Stop. The petitioner will be at liberty to file his reply before the returnable date. Paragraph lists the matter on July 25.
It will definitely serve by the 18th.
Yes,
It must be served by
only
18th.
one thing, madam. It is a 4-storied building. We have already started. We will also not stop. It will take some time.
We'll assess all that. 2 years have gone by.
Because when I will show the orders, I have already shown.
There is no because.
The occupants have already filed petitions. Thereafter got that they will vacate it, but they have not vacated. 6 months order was there. Not to pass any adverse.
Mr. Banerjee, we fail to understand if there's an order of the division bench which directs the KMC to do a certain thing. Can a learned single judge pass an order overriding such order?
I will not say anything.
What will happen to judicial discipline then?
I can show the orders. But fact is that Howrah Corporation is in trouble.
Unless our order was not placed before the learned single judge.
The order that we have already mentioned.
Stand of all the municipalities in all the demolitions order which has been passed by its honorable court.
come back on the
You
25th.
can show from the orders that we have
Some or
already
other
pointed
will have
out
to
that
keep the
this
proceedings
bench
pending.
has, honorable bench has passed an order.
And to make the order infractious in the process. That is the sole
We'll go into it next day.
Just for the information of the bench, I was not appearing before the single bench.
They will
change of
appear
counsel.
on the single bench because they will come new. Now,
Who is the commissioner now?
Bandana Pokri.
Was she ever with HIDCO? No.
Hitco.
Huh?
She was not at the highest rank. She was in the
Yes, yes,
next.
All right.
And she is always taking inquiry what order has been passed. What order has
My
been
lord, this commissioner had to appear in this honorable court number 8, my lord, in connection with another contempt application for demolition of another building. Mr. Banerjee was there.
And they were defending that.
I was not defending that.
If we issue a rule, she'll have to come again.
Again, but that is but
Yes,
they but
have
the
to.
petitioners here.
But that
they
will have the desired effect, I believe.
But in that case, my lord, my learned senior friend was there to stop the demolition.
I was not stopping the demolition. I was barely a witness there.
But now one thing has become a practice by the demolition authorities. Go and start demolishing the house without a plan. For demolition, there has to be a proper
Structural stability, my lord.
stability, whether the other side will be affected, that house will be affected. Nothing is done. They just take some hammers and they started building in the top of the house.
Not hammers.
Have you heard?
Photographs, my lord.
Have you heard of a health drink called Complan? They believe in Complan. Call the original side. শব্দের মতন তো শান্তি আমরা
Mainly takes the appellate side Millard appeal once.
Yes, Mr. Banerjee is not available, we presume.
Millard, he is in court number.
We are not concerned. Only thing, you start, you finish. We don't believe in relay, Mr. Dashgupta.
Very good.
Yes.
Millard kindly comes to page 7, Millard, the impugned order. Millard, just to Millard, 2 minutes, Millard, to refresh Millard, my lord's mind, Millard, memory, Millard, kindly comes to page 76 once. The last paragraph. Just quickly, Millard, judgment gulo bar kore rakho. Kalpal jaye jahate bar kore rakho. Millard, kindly takes page 76. Last paragraph.
Yes.
From the submission made on behalf of all the parties, it appears that there is a
76 of the stay petition.
yes. There is a dispute raised with regard to the ownership of 700 square meters of vacant land. The petitioners have not been able to produce document or title deed to show that the aforesaid 700 square meters were at all sold to the petitioners or were included in the schedule of the deed of conveyance of the petitioners. Prima facie, it appears that 700 square meters was separate and left out from the portion of the land sold to the petitioners. The petitioners rely on an affidavit affirmed by the Kolkata Municipal Corporation in an earlier writ petition in the year 2003 to show that the vacant portion was shown in the sanctioned plan, pursuant to which construction was raised.
the court fails to appreciate as to how the portion which was never sold to a party could have been shown as a vacant land for permitting sanction for raising construction thereof. An owner cannot lay claim over the contiguous land and in absence of a valid title deed. Till the land is legally sold in favor of the purchaser, the same cannot be treated as the property for the purchaser for obtaining sanction for raising construction over the property which is sold. The owner of the land who retained 700 square meters land on sold the same in favor of these private respondents. Kolkata Municipal Corporation mutated the land in favor of the private respondents and allotted SEC number and thereafter sanction plan for raising construction. Now, my lord, here the learned judge, to my respectful submission, has committed the error that the land which was left was a mandatory land to be left open under the old act, under the Calcutta Municipal Corporation Act. As per the sanction plan, if my building is more than 18 meters in height, I have to leave 50% of the total land. It was that land which was left open, and it's a mandatory space to be left open under the old act. Now, the same issue has been reaffirmed by the corporation in 3 affidavits, not once, since 2003 till the as late as in 2017. Now, the respondent number 6 director, Sanjay Singh, will recollect, Sanjay Singh also filed a written objection before Alipur court in a title suit filed by me that that land has been sanctioned to Anandalok. And that for the purpose of the construction by Anandalok. Now, my lord had clearly recollects all the 3 affidavits. Just for once, if takes the affidavit filed by Sanjay Singh, page 298 of the stay application, volume 2. Wait,
298.
298. This is a written objection filed in the suit of 2003 by the respondent defendant number 3. Now, kindly see page 299, para 4. That the averments made in paragraphs 1 to 8 of the injunction application are matters of record, and your petitioners does not admit anything which will not transfer from the record. Your petitioner admits that 700 square meters on the front side facing Acharya Jagadish Chandra Bose Road is still vacant as open space adjoining Anandalok building complex being a part of premises number 227 AGC Bose Road, where your petitioner has been using such space as car parking zone. The said open space is designated and marked as car parking space in the sanction plan of the building 2. So, this written objection kindly has been affirmed by at page 305 by Mr. Sanjay Singh, now the director of respondent number 6. So, these documents were available in the writ petition, appended to the writ petition, and that the writ petition clearly is on the very small compass that my representation which I have given to the corporation has not been even answered to, has not received any consideration. I only required a hearing under section 397. That's that's the smallest compass of that writ petition.
Oh, you applied for cancellation of?
Yes, of the sanction plan under section 397. 397 authorizes the commissioner to give us a hearing, whosoever writes. Now, that hearing, even my letter has not received the consideration. They have not thought it fit to give a reply even. Only for matter of just kind the sake of repetition, the letter, the representation is at page 365 of my lord's brief, 365. Same volume. Kindly see Milad paragraph 2 onwards. I will not read Milad and Milad kindly takes paragraph 11, page 368. Now Milad paragraph 10. Even Milad, prior to that Milad, I have given all the backgrounds of Milad, the litigation, those are pending. 10, 11, 12, and Milad, most importantly, paragraph 14, where I raise Milad a question of Milad misrepresentation and fraud practiced by our respondent number 6, and which is Milad the criteria to give me a hearing under 397. Milad, they can admit, they can refuse, they can reject, but Milad, I at least Milad wanted a hearing. Now, Milad, with this short compass, Milad, I filed a writ petition before the Honorable Single Judge, Milad, and this is the order impugned. Now, Milad, I have relied on the old Milad Corporation Act, Calcutta Municipal Act. Milad, the copies are there with your lordship. I will not repeat, Milad. Milad, as Schedule 16, my lord will consider. Milad, that schedule. Yes. Schedule 16, Edith Rule 15 and 21. Milad, I have to leave Milad a 50% of my entire land if my Milad building is more than 18 meters. My building is 21 meters in height. And Milad, this Milad, my landed senior Milad had shown that this Milad spirit has also been gone down to Milad 2009 building rules. That Milad, the mandatory space has to be left. Now, Milad, that property, Milad, then Milad, if today, Milad, even between two buildings, Milad, that no man's land on Milad, the land which we all leave Milad for the purpose of Milad mandatory space, then that will be given a separate assessed number and can be sold to anybody. And naturally, I will not have Milad a deed or a title deed or a deed of conveyance.
So this point was not considered.
Milad, this point was not considered. Milad, the learned Singaja has Milad gone on the total Milad a different aspect that I don't have a deed of conveyance. Judgment. Okay, 23.
Yes.
Now, Milad, though Milad, I have an unreported judgment of this bench, Milad, I'll give the report. It has been reported subsequently. Milad, bole dichi. Just give. Daro report ta bole dichi. Report hoyle to abar copy ki ache. Milad, reported in Milad 2023 SCC Online Calcutta 4070. Copy diye tha. Now, Milad, kindly see. I lost in this, Milad. I was.
Page number?
Milad, 4070. I know. Milad,
Mr. Roy Chaudhary, this matter could be cut short. All they want is a hearing on the 397. What do you say to that?
All these issues have been covered by my lord judgment. So I shall be, and also Justice judgment.
This particular issue, perhaps we did not consider.
I have not raised before.
And went all the way up.
From our order.
Previously, they moved a civil revision where Justice Mukherjee had passed a judgment saying, dealing with all these points. And this went up to Supreme. This I thought was placed for
No, that was on a different point, if we remember.
That was placed before your my lord, when dealing with the audience side.
building height issue, the building height. Not a building height. 397 capture of on the building height.
Whether an association can be.
Can file writ petition.
That's also given.
Anyway, no, we just made a suggestion. Otherwise, we'll hear you. Yes.
Millet kindly Millet takes this Millet judgment. Millet this judgment arises out Millet again Millet dismissal of a writ petition. Millet kindly Millet the learned single judge was the same and my lord is also the same. Millet a judgment and order.
We are also the same.
The same bench. Both the benches are same. A judgment and order dated September 13, 2023, whereby the appellant's writ petition, being such and such, was dismissed by the learned single judge of this court is under challenge. The writ petitioner approached the learned single judge alleging that the private respondents are raising illegal construction at premises such and such. The petitioner claimed to be the lessee of the property, which according to him is a Thika property. He prayed for a direction upon the Kolkata Municipal Corporation to demolish the construction and to set aside the sanctioned building plan that had been issued for the construction of the building in question. On behalf of private respondent number 6 and 7, it was submitted. Well, this was my submission before the learned single judge that the property in question in premise number such and such as claimed by the writ petitioner. The respondent number 6 said that he is the owner of the premises. The learned advocate appearing for the KMC produced a report of the concerned engineer Boros 4 and 5 of KMC before the learned judge, wherein it was mentioned that upon inspection of the site, the department could not locate the premises number such and such. The report further stated that KMC had sanctioned reconstruction plan in terms of Rule 2.3 sub-Rule 2 and E of the KMC building rules, read with Section 410 in respect of the premises. After noting the submissions made on behalf of the parties, learned judge dismissed the writ petition. Miller set out the portion. The learned advocate for the appellant writ petitioner says that the sanction of the building plan has been obtained by the private respondent by making gross misrepresentation and fraudulently. The appellant has made at least 2 representations to the executive engineer. The second representation was addressed also to the Director General of Building and the Municipal Commissioner. Learned advocate says that keeping such representation pending, effect is given to the sanctioned building plan which has been challenged by the appellant. This will result in demolition of a portion of the building of which he is the lessee. No further demolition should be permitted till the representation of the appellants are decided by the competent authority. Learned advocates for the private respondent seriously dispute the locus standi of the appellant to maintain the writ petition. They say that the appellant's predecessor in interest surrendered whatever right, title and interest he had in respect of the concerned property way back in 1996 in favor of the private respondent number 6. Learned advocates for the private respondent further say that no demolition activity is being undertaken. Construction is being made strictly in adhering to the sanction plan. Learned advocate for the appellant strongly disputes all the submissions made on behalf of the private respondents. Likewise, the learned advocates for the private respondent vehemently deny the veracity. Having heard the learned counsel for the parties, we are of the view and the justice will be served if we pass the following direction. 1. The appellants shall resubmit the 2 representations referred to above along with supporting documents, if any, to the executive engineer within 3 days from the date and shall supply copies of the representations and the documents, if any, to the private respondents. Upon receiving intimation of submission of representation by the appellant, the private respondents will be at liberty to submit the written statement along with the supporting documents to the executive engineer within a week thereafter with the copies of the written representations. Upon receipt of the aforesaid form, the appellant and the private respondent within 4 weeks thereafter, the executive engineer shall take a reasoned decision on the representations of the appellant in accordance with the law and the applicable rules and regulations after giving opportunity of hearing to the appellant. The decision so taken shall be communicated to the party in 1 week if the private respondent may continue the construction. Learned Millard, this is the Millard, same direction Millard that we want Millard from your lordship. It's the same case, same 397 representation given and Millard not considered. At least Millard in this matter, the second representation was answered to. But in my case, Millard, my representation had not received any reply even. And also Millard, in the same Millard as a coincidence, here also respondent number 6 was challenging Millard, my clients. and my lord, the learned single judge has dismissed the writ petition on the ground of locus standi.
Only distinguishing feature is the counsel on your other side.
My lord, I'll refer to my lord another judgment where my lord Justice Banerjee was my lord sitting with Justice Chellur. My lord 2016 SCC Online Calcutta 6764. The dispute between the two owners of property situated side by side had led to filing of this appeal. The appellant before us secured a plan which was revised so far as putting up construction on the existing construction according to the appellant. It is not disputed so far as the private respondent is concerned, his construction of the building is existing from 1950 onwards. And so far as the existing building of the appellant, it is in existence from 1972 onwards. The entire problem arose when the appellant obtained a sanction plan for the construction of the second floor and above. According to party respondent, there was earlier litigation between the parties again with regard to the encroachment, and at his instance, an unauthorized construction came to be demolished. This is with regard to the existing building. According to the appellant, if permission is granted by sanctioning the plan to put up further construction above the existing second floor, there could be no question of any encroachment upon the property of the private respondent. Be that as it may, unauthorized construction beyond the sanctioned plan has to be decided in accordance with the building rules and norms depending upon the floor area ratio. After filing of the civil suit for grant of injunction, since party respondent could not secure any order of restraint, he made representation to the Joint Commissioner and other authorities complaining about the sanction of the plan in favor of the appellant, which is not in accordance with the building rules and norms. According to the appellant, having delegated the power to decide on the representation of the party respondent, the municipal commissioner ought not to have entertained the representation or ought not to have interfered with the opinion of the joint commissioner by passing an order of such and such. As against this, learned counsel appealing for the party respondent submits that it was not suo motu exercise of power under section 397 of the Act, but after suffering a decision in the hands of joint commissioner on 1st June 2015, an appeal came to be filed before the commissioner. Therefore, the order dated such and such has to be considered. However, the learned single judge, having regard to the dispute between the parties, has opined both the orders of 19 June and 1st June 2015 deserve to be set aside and quashed, and accordingly quashed the same. He has also protected the interest of both the parties by appointing delegate in exercise of his power under section 48, subsection 3b of the said act to adjudicate controversy by a reasoned order upon notice to and hearing both parties. By this exercise, definitely whether the sanction plan, which is already in favor of the appellant, is in accordance with the building norms, law, etc., will be decided. So far as the encroachment and the other civil rights between the parties, it cannot be decided by the respondent authorities since the jurisdiction based is civil court. Having regard to the above factual matrix, it would be just and proper for the appellant not to put up any construction over the disputed property area of 220 square feet till the entire matter is decided by the civil court with regard to the right, interest, and title over the property. And now, the order was not interfered.
So you have completed.
This is insofar as the appeal is concerned.
Yes, appeal 39 Milad, the appeal is concerned. They want that. Well, gives you a moment. Milad, again, my lord judgment. Milad 2024 SCC Online Calcutta 2528. Huh? Most recent one.
Sweetheart.
Now, my lord, kindly takes para 15. Page 9, para 15.
Yes.
Respondent number 6 and 7 in this appeals, that is Larika, and another were the writ petitioners before the Honorable Single Judge. The learned senior advocate representing them submitted regarding the preliminary point of maintainability of the writ petition that the Honorable Single Judge has found title dispute between the parties not to be there. According to the court, the vendor and the developer both are parties to the deed of conveyance and the documents are undisputed. The court held further that as the deed of conveyance executed in favor of the said respondents was not disputed, no title dispute can be said to have been alleged. It is submitted further that the respondent corporation has not only mutated the name of the writ petitioner but has also accepted municipal taxes and charges over the proportionate share of the building under the writ petitioner's ownership. According to the learned senior advocate, the report filed by the respondent corporation would indicate in no uncertain terms that before obtaining the grant of sanction in respect to the constructions over the undivided roof, the appellants have not disclosed and has willfully suppressed the fact that the undivided half share of the same has already been transferred in favor of other persons, that is his client, the writ petitioner. According to the learned counsel, this is an appropriate case to be made out under section 397 of the KMC Act for cancellation of the additional sanction plan. The learned senior advocate has objected to the contention of the appellants that the dispute involved in the writ petition appeal is a private dispute between the parties and submits that there would not be any element of private dispute over the title of the property brought before this court. On behalf of the writ petitioner, the learned senior advocate has made reference to the objection letter dated September 9, 2011, sent by his client to the respondent corporation, and says that the factum of fraud and misrepresentation as has been exercised while seeking sanction of the additional building plan has sufficiently been brought on record by his client. According to the learned senior advocate, the contentions in the letter would have been sufficient for the respondent corporation to initiate a proceeding under section 397 of the Act in order to make an inquiry as to the misrepresentation and fraudulent conduct by the present appellants in obtaining the sanction of the plan. That municipal corporation has failed as a public authority to exercise power as vested in it by law. The respondent corporation, having failed miserably in following up the due process of law in redress of the grievance of the writ petitioner, is evident and gross. Under such circumstances, the said writ petitioner's respondent shall have redress of their grievance only before the writ court, and relegating before the corporation would be a futile exercise. The learned senior advocate relies on the judgments and to submit that in view of specific factual backgrounds of this case as mentioned above, this court would have ample authority to intervene. The following portion of the judgment Millard are stated. Now, Millard kindly comes to paragraph 16 at page 30.
Come back on the 25th. We'll assemble 2 weeks after 2 weeks.
My apologies, Milord, for not remaining present at the first. I ought to have. I was on legs, Milord. I sincerely apologize.
Learned advocate for the... So you have concluded your argument in the appeal.
Millard, two judgments are there. Millard, only Millard Supreme Court যেখানে বলেছে
আগের স্টোরেজটা ছিল, লাস্ট স্টোরেজটা ওটা শীট কোথায়? এরকম মোটা ফাইল হ্যান্ডেল করা যায় না। Representing the appellants as well as the review applicants, resumes argument on behalf of his clients, but does not conclude. Paragraph lists these matters once again on July 25, 2027.
2025. Oh, that was it. I got it. Got it slightly late. This was a nice parting one, my lord, for the weekend.